Ladies and gentlemen, may I have your attention, please? We would like to inform you that the program will begin approximately 15 minutes later than scheduled, as many participants have not yet arrived. Thank you for your kind understanding. Good morning, distinguished guests. The second day of HCCH Asia Pacific Week Seoul 2025 will begin shortly. For those who are outside the conference room, please make your way inside and take your seats. As part of our commitment to the UN Sustainable Development Goals, this event is being held in paperless manner. Presentation materials can be downloaded from the official website by scanning the QR code on the event poster. And simultaneous interpretation service is also available today. Please take your receivers on the table and select your preferred channel. Channel 1 is Korean and channel 2 is English. We kindly ask you to turn off your mobile phones or set them to silent mode during the whole conference. Thank you for your kind cooperation. Good morning, distinguished guests. Welcome to the second day of HCCH, Asia Pacific Week Seoul 2025. I'm Dr. Hyojung Kim, professional researcher of Judicial Policy Research Institute. It is a great honor and a privilege for me to serve as your MC for the day. On behalf of the organizers, I would like to express my heartfelt gratitude to all of our distinguished guests for taking the time out of your busy schedule to join us. I hope everyone has slept tight last night and ready to participate in inspiring sessions today. We have exciting and intellectually engaging sessions lined up today. We'll address some of the HCCH's most significant instruments with a particular focus on the Service Convention, the Evidence Convention, the Choice of Court Convention, and the Judgment Convention. Today's sessions are designed to provide a critical analysis not only of the evolving landscape of international judicial cooperation in civil and commercial matters, but also of the intricate issues surrounding jurisdiction and the recognition and enforcement of foreign judgments. I'm sure that the insights shared today will make a valuable contribution to ongoing academic discourse and help inform future practice. Without further ado, let us begin session 4. Our topic for the session 4 is the HCCH, the benefits of membership and key conventions. In session 4, we'll hear from 3 distinguished speakers. Before we begin, please allow me to remind our speakers to stay within their allotted time. Now, it is my great honor to introduce our 4th speaker, Dr. Christophe Bernasconi, Secretary General of the HCCH. Please join me in welcoming him with a big round of applause.
Thank you very much, and a heartfelt good morning to all of you. I hope you enjoyed your evening, and thank you for joining us for this second day of our Asia Pacific Week here in Seoul this year. I do understand that the title of this session is Benefits of Membership and Key Conventions. But before I talk a little bit about the actual benefits of membership and some of the key conventions, I thought it would be helpful to draw the picture of where we currently stand in terms of membership and the overall ratifications and accessions to our conventions. And I'm really grateful for having included this topic in the program of our meeting, because we do actually have a number of states present either here in person or online that are either not a member but a contracting party to one of the conventions, or who are not connected at all to our work. So, for example, we have, I don't know if they are here in person or online, but representatives of the Democratic Republic of Congo, who is not connected at all. That is one of the African states that is not connected at all to the work of the HCCH, but which we would very much like to see join the convention or the organization even better. Then we had, for example, also representatives from Jamaica. Jamaica is a state that is already party to 2 conventions. Kuwait, 3 conventions. Pakistan, 3 conventions, but these are all non-members of the organization. Sierra Leone, 0 conventions, not a member. Bhutan, 0 conventions. Guatemala is in the process of becoming a member, but is currently already party to 3 conventions. Indonesia joined the Apostille Convention a few years ago, but is not a member yet. But I hope that something will happen in the course of this year. I know that the file is quite active. And then we have Papua New Guinea, also not connected at all. So enough of states, I think, that really would benefit from considering membership and or joining some of our conventions, hence the session here this morning. So I would like to start by recalling that As we speak, the HCCH has 92 members. That is 91 states plus the European Union, which in addition to its own member states is a member of the HCCH in its own right. Now, where do these members come from? We divide the world in 4 regions, basically, the Americas, Europe, Africa, and Asia Pacific. And here you have the number of members in these various regions. You see that Europe is strongly represented. Africa is clearly underrepresented, and this is really part of our efforts, our strategic efforts to increase the visibility of the work of the organization in Africa. And there was one really important development very recently when our council in March earlier this year approved the proposal from the government of Morocco to host a regional office of the organization in Morocco. So we have a regional office in Buenos Aires since 2005. We have a regional office in Hong Kong since 2012. And we'll have, as of this year, a regional office in Morocco for Africa. And I very much look forward to using that platform, as it were, to, again, promote the work of the HCCH across the African continent. The Americas, 18 members. There is also some work to do, but in particular also in Asia Pacific, you see that we only, quote unquote, have 21 members in the Asia Pacific region, and there is also room for more membership there, clearly. It's interesting also to ask oneself, what is the percentage of states in a region that are members of the HCCH? And obviously that percentage is very high in Europe because almost all European states are members of the organization. But you see that in the Americas about half of them are members. In Africa it's only 17%. And in Asia Pacific it's just above a third of the states that are members. And that again also shows that there is room for improvement really, and we do encourage these states to really consider becoming a member and benefit from the advantages of being a member, and I will talk about these in a few minutes. But in addition to the members, we do of course have an important category of non-member contracting parties or states. So these are states that without being a member of the organization are party to one or more of our conventions. Some would call them free riders. I sometimes use that term as well. So these are states that benefit from the work of the organization without actually contributing to the budget of the organization, which is perfectly fine for some time. But once a state has been a party to, say, 3-4 conventions for a certain time, they typically get a nice letter from me encouraging them to become a member, and sometimes this works and sometimes we just have to be a bit more patient and let time do its effect. But 66 non-member contracting parties is of course an important number of states, and they are therefore also connected to the work of the HCCH, and you see where these are coming from. So in Americas we have almost the same number of members and non-member contracting parties. In Europe that number is obviously very low. In Africa you see that we have a considerable number of states that are non-members but are party to at least one convention. And then again in Asia there is a number of states that are already familiar with the work of the HCCH that should use, in my view, this foundation, as it were, as a platform to go one step further and also become a member of the organization and not just a contracting party to one or more conventions. So if we then look at the global coverage of the HCCH, we see that if you take the 92 members and the 66 non-member contracting parties, the total number of connected parties or states is 158. And that, I think, is a very solid number that does reflect the fact that the HCCH clearly has a global mandate, does not really have yet a global reach in terms of membership, but in terms of connections, I think we can comfortably talk about a global coverage of the HCCH, even if, again, there is still a lot of work to do. And that leads me to one important figure that I like to share, and some of you have seen this figure already, but I like to recall the total number of ratifications or accessions to our conventions that we have. And as we speak, and as a result of last week's ratification by Korea of the Adoption Convention, this total number of what we call treaty actions is now 1,036. So 1,036 times has one of our conventions been brought into effect in a state or in a contracting party. That, I think, is a remarkable figure that shows that the work of the HCCH is visible, is active, is being used by the states. These conventions do have an active life, and that, of course, is excellent. And I also always like to put this figure into perspective by always asking oneself, how many bilateral agreements would it take to achieve the same network of treaty relations between states? So in trying to do the same thing as we do at the HCCH on a multilateral basis, but try to do this on a bilateral basis, well, you would need now more than 33,000 of these bilateral agreements to achieve the same result. And I think that shows how effective multilateralism can be, how effective the multilateralism as produced by the HCCH actually is, because through this multilateralism, states save a lot of resources, human resources, technical resources, financial resources, if and when they are an active actor within this multilateral platform that the HCCH offers. And that figure, of course, keeps growing. We have somewhere between 12 to 15 of these ratifications or accessions every year. And that's certainly very encouraging. It's also interesting to know where these treaty actions actually come from. So 1,036 is across the world. Most, again, come from Europe. Obviously, we want to change that. We do encourage states from the other regions to join. One figure that always hurts my feelings is Africa, clearly underrepresented also in terms of treaty actions. But look at the figure of Asia Pacific, and I think there also with 144 treaty actions so far, more could be done and should be done to really let all these states in the region benefit from the work of the organization. And here you have the equivalent percentages of where these treaty actions come from. And with that, we can then briefly talk about the benefits of becoming a member of the HCCH. And I think there is one expression that basically summarizes it all, and that is a seat at the table. Only members take decisions within the HCCH. And these decisions include, for example, the possibility to determine the work program of the HCCH. What are the new topics or the new conventions that we should be working on and develop? And that, of course, is a decision taken by our Council on General Affairs and Policy, the highest organ of the organization that meets once a year to, amongst other things, discuss the work program. And again, only members take these decisions. And it's also only members that actually negotiate new instruments. So it's the members that co-shape this global consensus that is the result of the work of the HCCH. And consensus is a very important word because all our activities are consensus-based. All our negotiations are consensus-based. We haven't taken a single vote in the course of our negotiations since roughly the year 2000. And I think that is a remarkable development as well. But as a member, you then also have the possibility to bring in your own expertise in these negotiations. And by doing so, a state and a member enriches the diversity of perspectives. And for a global organization, this is, of course, extremely important. And by having this seat as, at the table, you then can also ensure that your own national interests are being addressed effectively, that they are taken into consideration during the negotiations, and that the proper solution is being found. And with all of that, as a member, you have ownership of the work and of the outcome and the output of the organization. So instead of just taking over what has been negotiated by others and a result on which you didn't have any impact, well, as a member, you can again co-shape the result of these negotiations and therefore really have ownership of the co-ownership of the process. As a member of a specific region in these negotiations, in these discussions, you can then also strengthen the voice of a region, and that's very important. Of course, the bloc of the European Union is very coordinated and they speak with one voice. We see that more and more the Latin American states are also very coordinated in their positions. Well, why not have a strengthened voice coming from Asia Pacific, or hopefully also a strengthened voice coming out of Africa to be heard in the discussions and negotiations at the HCCH? So I think that is also a significant advantage of being a member and being a member of a certain region that talks as a region in the organization. And with all of that, you strengthen, of course, the universality and the inclusiveness of the HCCH. That is a very important strategic goal of the organization that is expressly reflected in our strategic plan that covers the period 2023 to 2028. We do a lot of efforts trying also to implement this strategic goal through new members. And as a member, you also have priority access to technical assistance. Now, with technical assistance, it's a bit like habitual residence. There is no clear-cut definition of what technical assistance actually means or is, but it's basically anything that goes clearly beyond a mere seminar, a mere workshop, or a two-day event to talk about the work of the organization. Technical assistance would typically involve, for example, sending an expert to a state to help the state with the implementation of a convention in terms of looking at the implementing legislation, setting up a central authority, training the operators of a convention, sometimes training judges that will operate the convention. So it's really a more in-depth connection with that state that also lasts longer. We typically do technical assistance, in particular in relation to the adoption convention, and there we have had missions that lasted 6 months, where not a member of the PB, but an expert that we would have identified then goes 6 months to a state and helps with the implementation and setting up of the relevant authorities and all the related training. But we can only do that for members. Non-members do not benefit from that type of work. And last, but certainly not least, I think you get these benefits as a member at an excellent cost-benefit ratio. The overall budget of the organization is now roughly 5.4 million euro. We have, 7 big payers, Canada, the US, UK, France, Germany, Japan, and China. They pay the equivalent of about 250,000 euro each as a contribution to the organization, but you see that the median contribution amongst all current members is about 24,000 euro. That is the equivalent of what we call three budget units. I don't want to go into any details, but we follow an adapted version of the UPU system, the system of the Universal Postal Unit. But what I think is important to note is that most of the new members would actually pay less than this median fee of 24,000 euro. There are, of course, a few exceptions. For example, Pakistan that I mentioned would pay more, or Kuwait would pay more, or Indonesia would also pay more. But some of the other states that I have mentioned would only pay one unit. In the case of, Sierra Leone, for example, even just half a unit, that's about 4,000 euro. So all this to say that I think the financial implications of membership cannot be an obstacle to really becoming a member of the organization, because the membership fee is clearly very reasonable considering all the benefits that a state gets. Moving on then to the benefits of joining conventions, that is a bit more difficult to address in a very general way, because of course the benefits really change from one convention to another. But typically these conventions, they offer very practical and efficient solutions, and in particular for well-established conventions like the apostille, service evidence, abduction, adoption. These are, conventions that have been out there for some time. They clearly provide a well-established international legal framework that is largely seen as establishing an international standard. A standard that, in particular, commercial operators often expect to be in force in a state before they do business in another state, because it's very much part of the legal framework that they expect to benefit from when they do business in a specific state. And these conventions then, of course, also offer legal certainty and predictability because of the clear framework that they provide. And they are, of course, also the basis for enhanced international cooperation, as we have seen yesterday and as we will no doubt hear also in the course of today. The beauty of unifying private international law as opposed to substantive private law is that the domestic legal systems remain largely untouched. It's like, we always like to use this image of bridges. Unifying private and national law is like building bridges across different legal systems, but at both ends of the bridge, the domestic legal system remains largely untouched. And I very much like this figure because the unification of private and national law is unification while one does respect the diversity of legal systems in the different states. Now, I say minimal impact, we have to be careful because in the course of the negotiations of new conventions, we do hear from time to time states say, oh, I can't adopt this position, I can't support this proposal because it's contrary to my internal legal system. Well, this is where you have to really look into the matter very specifically and assess whether the international solution that it would be proposed in a future HCCH convention is not better than what you currently have in your domestic legal system. Take the example of what we heard yesterday from our Korean colleagues as to what they have done internally to change their domestic system with a view to joining the adoption convention. That, I think, is an excellent example to show that the international legal framework can often be superior to what states have in their current legal systems. And so therefore, in the course of negotiations, some flexibility may be required to achieve a meaningful global result. But again, the principle is that private international law would not have much of an impact on the domestic legal system. And of course, by joining these conventions, there are a lot of resource savings involved, as I mentioned already, human, technical, and financial, when you apply the same convention in relation to 10, 15, in the case of a few conventions, more than 100 contracting parties, as opposed to try to do this on a bilateral basis, for example. And again, these conventions, they are clearly designed to be applied at the global level, but they also enable states from a region to actually strengthen the regional integration. And there is a nice little story that I always like to mention in this regard. We have been asked in the past to contribute to developing a mini apostille convention for ASEAN, for example. And we said, with all due respect, no, why would we do that at the HCCH, and why would you do that within ASEAN? Just join the global treaty, and you have the facilitated circulation of public documents within the 10 ASEAN states, but at the same time, you also have it with the rest of the world. And that is what this strengthened regional cooperation and integration is all about. So there is no need to reinvent the wheel each time you want to do something at the regional level, when there is actually a global solution that is available. These conventions facilitate the mobility of people, goods, and capital. The world in which we live, as I like to say, is a world of private international law, and so these principles are very important. And through these conventions, of course, there is basically the protection of children. We have talked yesterday a lot about the UN Convention on the Rights of the Child as a framework convention, but it's really the HCCH conventions that give real effect to these fundamental principles that are mentioned in the UNCRC. But the same is true also in the transnational litigation or the commercial side of things, where our conventions really provide the basis for rule-based multilateral trade and commerce, and in the future, hopefully also for the digital economy. Fast-moving field, but still in need of rules that would apply at the global level. And finally, last but not least, some of this work does, of course, also enable states to contribute to the UN Sustainable Development Goals, in particular SDG 16.2, that talks specifically about the protection of children. Well, you know, the suite of children's conventions we have clearly is an important contribution to SDG 16.2, and 16.3 that talks about the rule of law and equal access to justice, of course, is also very relevant in relation to the work of the HCCH. I leave it at that. That was a quick kind of snapshot overview of the benefits of becoming a member or joining conventions. If you represent a state that is either not a member or not yet a party to some of the conventions that are on the program, have been discussed yesterday or will be discussed today, we'll be more than happy to answer any questions you may have, either bilaterally during the breaks or maybe even at the end of this session if we have still some time. But thank you very much for your attention.
Thank you, Secretary General, for the informative and inspiring presentation. Our second speaker is Mr. Yun Zhao, representative of the Regional Office for Asia and the Pacific at the HCCH. He'll focus his presentation on how the HCCH builds legal frameworks that bridge diverse legal traditions and foster cross-regional cooperation. Please join me in welcoming our second speaker.
Thank you. Good morning, ladies and gentlemen. It is a great honor for me to be here to talk about the importance of HCCH and its conventions for our region. The success of the HCCH Asia-Pacific Week in the past years have clearly demonstrated the significant relevance and potential of the HCCH and its conventions for our region. I'm very pleased that this year we are able to continue our tradition, and thanks the Korean government to host this major event in our region, the Asia-Pacific Week provides an important occasion for us to share and exchange views in the field of private international law. We are all very proud that we share the same tradition. The rapid expansion of cross-border transactions, mobility of people, and family relationship within and outside our region would all benefit from the support of international legal framework. As the Secretary General of the HCCH has pointed out, the HCCH has taken this important role to facilitate international transactions and protect the interests of vulnerable parties involved. The HCCH conventions help to promote cooperation among courts and other authorities that are indispensable in an age of globalization and progressive regional integration. When compared with other regions around the world, the Asia-Pacific region is unique in many aspects. First, it is a region made up of many countries, and their geographical dispersion makes travel, including dispute resolution, more expensive. Second, the region is populated with common law, civil law, and hybrid legal systems. Third, multitude of different languages is spoken, making it more difficult for parties to access and understand the laws and procedures of countries they engage in business with. And fourth, the region is also made up of varying level of economic growth, resulting in considerable difference in the sophistication of court practices and procedures. The Regional Office for Asia and the Pacific, or we call it the ROAP, set up 13 years ago in 2012, plays a role to strengthen the ties between the HCCH and the states in the region. The photo basically shows this building where the ROAP locates. It is an essential part of Hong Kong. The ROAP has aimed to promote the HCCH and its conventions by increasing awareness of the value of the HCCH members and the usefulness of the conventions in the region. It also brings benefits in terms of assisting states with the implementation of the convention. As the HCCH influence becomes more and more global, a growing number of Asia-Pacific countries join the HCCH and its conventions, both benefiting from and contributing to this renowned organization. Since 2000, the number of HCCH member states have grown rapidly. This is also the same for our region. The region includes some of the world's most populous nations and some of its most commercially energetic areas. As people in the region grow in affluence, as they travel more, as borders become more fluid, so the work of the HCCH grows in relevance to the needs of the region. Although the states in our region are geographically close, they represent a wide variety of cultures and legal traditions. The HCCH conventions, which are intended to bridge different cultures and legal traditions, are therefore very useful to providing a framework for cooperation, both for the states within our region and between those states and those located outside the region. The increased membership base in the region will bring wide representation of a diverse range of legal traditions to the HCCH and help the HCCH to develop new instruments better adapted to the needs of our region. It will also assist in raising revenue, help to reduce expenses for the services already provided to state parties in the region which are not yet members to the HCCH, and facilitate ratifications or accessions to the HCCH conventions by the states in our region. The value of a convention, as well as its value to individual state parties, will generally increase in proportion to the number of state parties to the convention. Increasing the number of state parties to the HCCH conventions in the region will provide additional opportunity for enhancing certainty and predictability of cross-border private, commercial, and financial transactions and relationships, promoting judicial and administrative cooperation, and reinforcing protection of children and other vulnerable persons in trans-border cases covered by the HCCH conventions. Benefit will accrue within the region and also between states in and outside the region. Apart from connections with civil law countries and common law countries in our region, the HCCH also keeps good relationship with Muslim majority countries in the region. We can see the desire and realistic needs of countries that use Islamic law to join the HCCH conventions. Representatives from these countries were invited to attend conferences, lectures, and seminars, and other activities. All of this allows the HCCH to have a better understanding of Islamic law so that the HCCH can adjust related projects and interpret the conventions according to actual needs. This is also one of the most important reasons for the success of the HCCH conventions. Yesterday, when we talked about the family law issue, we also talked about the Malta process, which I would like to mention that the Malta process served as a successful example in promoting cooperation with countries with legal system influenced by or based on Sharia law for the international protection of children and the resolution of complex trans-frontier family conflicts. A win-win process can not only save the judicial cost of each country, but also better realize the unification of private international law among different civilizations. In terms of cooperation between international organizations, HCCH has maintained close relationship with ASEAN, the Organization of Islamic Cooperation, ELCO, and other international organizations and regional organizations. I would specifically touch upon the ASEAN. The HCCH keeps close communications with ASEAN as well as its member states. It is noteworthy that 5 out of 10 ASEAN member states, Singapore, Malaysia, Thailand, the Philippines, and Vietnam, are all members of the HCCH. The other members like Brunei, Cambodia, Indonesia, Laos, and Myanmar have either joined one or more HCCH conventions or participated in events related to the HCCH. An important objective of ASEAN is to accelerate economic growth, social progress, and cultural development. This can be achieved by active collaboration and mutual assistance on matters of common interest in legal, economic, and social fields among ASEAN member states. The ASEAN has emphasized the significant role of a sound legal framework in fostering economic and social development. The long-term sustainability of the ASEAN rely on civil procedures and commercial laws across ASEAN members being streamlined and modernized. A more uniform and harmonized legal framework will enable existing domestic infrastructures to facilitate the fair, efficient, and cost-effective resolution of disputes between businesses and people from different ASEAN states, enhancing cooperation and create a stable, prosperous, and highly competitive ASEAN economic region. The ASLOM HCCH consultations was carried out, promoting the synergies and cooperation between the HCCH and the ASEAN. The HCCH conventions are of significant practical importance in the implementation of the economic integration initiatives, in the promotion of inclusiveness and a harmonized cross-border legal framework. To sum up, the HCCH conventions and instruments provide those whose lives and activities across the borders between different legal systems with a high degree of legal certainty and predictability. Apart from enhancing the ease of doing business, they also establish effective state-to-state judicial and administrative cooperation mechanisms that can overcome the challenges of cross-border procedures and promote the orderly and efficient settlement of disputes, good governance, and the rule of law. The HCCH works for people and businesses alike, effectively helping them to overcome the daily practical challenges of private international law issues. The HCCH conventions have a direct impact on people's lives and the way commercial operators conduct their cross-border business. The impact of the HCCH convention is rising. A changing global environment, fanned by new technologies and digitalization, requires strong frameworks which accommodate pragmatic differences between jurisdictions that otherwise would prove significant obstacles to trade, commerce, investment, and mobility. This is particularly relevant to the Asia-Pacific region, with rich cultural background, legal systems, and largest population. There is no doubt that the HCCH conventions will bring about much practical benefits to our region in building bridges between legal systems and reduce obstacles to cross-border dispute resolution and reinforcing legal certainty and security across border, increasing the awareness and increasing the ease with which a commercial policy and human capital can be best leveraged in a dynamic and fast-paced environment in our region. So with this, I conclude my presentation. Thank you very much. Thank you very much.
Thank you, Mr. Zhao, for the insightful presentation. It is my honor to introduce our last speaker, Presiding Judge Ji-Yong Zhang, Director General for the International Cooperation at the National Court Administration. Judge Zhang will highlight the Korean judiciary's ongoing efforts to implement the key instruments of the HCCH. Let us welcome him with a warm round of applause.
Good morning. Distinguished guests and colleagues, my name is Ji-Yong Zhang, and I'm a judge and director general for international cooperation at the Supreme Court of Korea. It is a great honor to be here to speak at the HCCH Asia Pacific Week and to present the Bridging the Hague and Seoul. Everyone is talking about bridging today. This is not a seminar about the construction, but I'm also talking about the building bridges. Today, I would like to explore the connection between the HCCH and the Republic of Korea. At the private international law, as you all know, the connecting factor is very important term, such as a habitual residence and the domicile and the nationality, which serves to link a legal issue to a specific legal system. And I'd like to say that I would like to serve as a connect personnel, and let me now explore the journey to current collaboration between the Korea and the HCCH. These are the table of contents. This presentation will cover the three main areas. The first one is history, and the second, building bridges, and third, the future of judicial cooperation. Let me explain the connection between The Hague and the Seoul, Seocho district, Seochogu. And The Hague is globally recognized as the city of peace and justice and the capital of the international law. Likewise, the Seoul and Seochogu envisions itself as a leading justice hub in the Asia-Pacific region. And this vision drives our efforts to foster judicial cooperation in this Asia-Pacific region. I'm also serving as a member of a committee for the Asia-Pacific Justice Hub. A pivotal figure in this history is Tobias Arthur, the recipient of the Nobel Peace Prize. And he founded the HCCH, the Conference on the Private International Law, in 1893. And 6 years later, the first peace conference was held in The Hague, and which established the permanent PCA, the Permanent Court of Arbitration, which mediates the disputes between the countries. And as you all know, the second peace conference was held in following 1907. Tragically, during this second conference, a Korean delegation led by Lee Jun, a judge and prosecutor, was denied to their participation. However, their journey to The Hague symbolized Korea's early efforts to assert its sovereignty on the international stage. And if you look at the photo on the left downside, this was taken in 2017, The Hague Asia Pacific Week, and Christoph and I was in front of the Ijun statue, which is located in the Seoul National University. The first part is a history of judicial cooperation. And let me explain the start of the judicial cooperation in Korea. The Korea Private International Law Association was established in 1993, and I'm also the executive member of the COPILA. And 4 years later, the Korea joined the HCCH as a 45th member. Now you can see that there are more than 90 member states. And at the same year, the Supreme Court of Korea appointed the first Director of International Affairs, Judge Yoo Young-il, who is sitting at the center table today. And I really appreciate his effort to make the international affairs. And then he also made a committee for the judicial assistant in 1997. And Professor Seok, the president of the COPILA, also worked at this committee. And then we hosted the Conference of Chief Justice in Asia Pacific in 1999. And there was a Seoul Statement on Mutual Judicial Assistance. And next year in 2026, we will again host the Conference of Chief Justice in Asia Pacific in Seoul. Next slide is about the bilateral treaties concluded between the Korea and other states. The Treaty on Judicial Assistance in Civil and Commercial Matters were concluded between Australia, China, Mongolia, and Uzbekistan and Thailand. If you look at the second row, the Mongolia and Uzbekistan and Thailand are a member, have not joined yet to the Hague Convention on the Service and Taking Evidence. So we can send a document of a trial to these three states by the bilateral treaties. And also the Republic of Korea joined the Hague Conventions, the Hague Service Convention, and apostasy, and evidence, and child abduction. And as you all know, we ratified the Adoption Convention a few days ago. And the building bridges. We have a secondment system of judges, Korean judges, to the Permanent Bureau of the Hague Conference. The first judge and secondman was Judge Jung-hoon Park, and since 2010, 13 judges were seconded, including myself. And there was an MOU between the National Court of Administration and the HCCH in 2017. And the Korean universities, Seoul National University and the Jungang University also concluded the MOU between the Permanent Bureau of the HCCH. Right down, you can see my presentation 8 years ago on this stage. And the HCCH AP Week was held in 2017, and I was very proudly and say that I prepared this conference 8 years ago, and I'm very much touched. It was the first official event, HCCH event in Korea, and it was to celebrate the 20th anniversary of joining Korea's membership to the HCCH. And this also led to the revision of Korea's private international law, Private International Act, which introduced the provisions on direct jurisdiction, a development closely aligned with the ongoing work at the HCCH jurisdiction project. And as a former researcher at the Judicial Policy Research Institute, JPRI, I'd like to introduce several of its key publications that support the international judicial cooperation, the recognition and enforcement of foreign judgment with Dr. Kim, and international e-service and internet-based international jurisdiction and judicial interaction. And from this year, the JPRI has begun publishing research paper in English. You can find the recent works in the book, distributed today, the Compendium of JPRI Research Reports. And next slide. Let me talk about the future of judicial cooperation. The Korean judiciary adopted the next generation system this year, so we are using smart court, using big data and mobile e-litigation service, and the help from chatbot and automatic defect check is available nowadays. So this is a virtual trial, and this is the last slide, and let me talk about the future of the Hague Convention. If we look at the apostasy convention, we can use the e-apostasy, and then with regards to the service convention, e-service is undergoing, and about the evidence convention, we can use the virtual system and virtual witness hearing instead of the traditional one. And then about the judgment convention, we can think about the e-judgment as well. And other topics and projects, including jurisdictions, CBDCs, and digital economy, and digital tokens are ongoing. And I think at the digital stage, we do not need more wet ink or analog style, the judicial cooperation. Instead, we can step forward to the digitalized and the future technology. This is the end of my presentation, and thank you again, and I'm really moved to be here as a former secondee. Thank you.
Thank you, Judge Zhang, for the forward-looking presentation. I appreciate all participants of Session 4 for your thought-provoking presentations. This brings us to the end of Session 4. We'll now recess and reconvene at 10:50 a.m. So please help yourselves with refreshments available at the lobby. Thank you. Yeah, distinguished guests, we are soon starting handbook launch ceremony. Please make your way to the conference hall and take your seats. Thank you. We will now begin the launch ceremony for the 5th editions for the handbooks on the 1965 Service Convention and the 1970 Evidence Convention. It is my great pleasure to introduce Judge Min-ho Do, currently on secondment to HCCH, who will first present an overview of the updates and then invite the Secretary General for commemorative remarks. Please join me in giving him a big round of applause.
Distinguished guests, ladies and gentlemen, good morning. My name is Min-ho Do, and I'm a judge from the Republic of Korea, currently serving as a judge on secondment at the Permanent Bureau of the HCCH since August last year. It is a great honor for me, as a member of the Permanent Bureau, to stand before you today to present the 5th editions of the practical handbooks on the Service and Evidence Conventions. The 1965 Service Convention and the 1970 Evidence Convention facilitate and streamline the service of documents and the taking of evidence by promoting judicial and administrative cooperation in cross-border civil procedure. These conventions are widely regarded as highly successful and essential instruments in the field of transnational litigation. The handbooks aim to assist the wide range of users of the conventions with the understanding and implementing them effectively and efficiently. Since the publication of the 4th edition of the Service Handbook in 2016 and the Evidence Handbook in 2020, the 5th editions are now being finalized. They will be available in the HCCH's 3 official languages, English, French, and Spanish, and will be published in both ebook and print formats. The revision of the handbooks involved extensive collaboration with contracting parties to the conventions. Led by Melissa Ford, who has been excellently leading the Transnational Litigation and Apostille Division, and with the support of colleagues at the Permanent Bureau, the work on these handbooks has benefited from the contributions of experts and practitioners from around the world. I also took part in this work, contributing, perhaps surprisingly, my specific expertise in distinguishing between given names and surnames of Korean delegates. The new editions incorporate a broad range of updates, including evolving practices, case law, and technological developments. They are the result of several important efforts. First, the Permanent Bureau has continuously monitored the operation of the conventions, collecting information on new case law, legislation, literature, and technological developments. We also sought feedback from members and central authorities. Questionnaires circulated in 2022 provided valuable insights into national practices. The consultations conducted in 2023 and 2024 regarding the updated versions of the handbooks allowed for meaningful feedback and, where needed, in-depth discussions. Furthermore, during the Special Commission in July 2024, 260 participants from various countries engaged in 4 days of active and engaging discussions on the practical operation of the Service, Evidence, and Access to Justice Conventions. This led to the adoption of 138 conclusions and recommendations, the biggest number ever for the Special Commission conclusions and recommendations. All this input from monitoring, the questionnaire, the consultation, and the Special Commission has been duly considered and integrated into the updated handbooks. The Working Group on Handbooks, established under the 2024 CGAM mandate and working closely with the Permanent Bureau, took the lead in reviewing and refining the texts, resulting in valuable and constructive discussions. These collective efforts led to a valuable and practical revision of the handbooks. I would like to introduce another important update, the inclusion of reference to country profiles. These online profiles provide practical, country-specific information about each contracting party. Under the newly developed format, this information will be available on the HCCH website. The handbooks now guide users to consult the relevant country profile, enabling requesting entities to access accurate information easily without having to contact the requested state's central authority directly. This will undoubtedly save time and effort for the litigants and reduce the administrative burden for the authorities. Finally, let me highlight one significant change in the evidence handbook. It now includes the guide to good practice on the use of video link, fully embedded within the handbook itself. Video link allows 2 or more locations to interact simultaneously through two-way video and audio transmissions, enabling the taking of evidence in cross-border procedures to be carried out much more efficiently. Users no longer need to consult the guide separately, and the inclusion reflects both current practice and technological advancements, helping users implement the convention more effectively. And that concludes my introduction to the revised handbooks. I now have the pleasure of inviting the Secretary General, Dr. Christoph Bernasconi, to the podium to deliver his remarks and to officially unveil the handbooks. Thank you.
Thank you very much, dear Minho, and I think you set the stage so nicely that I can be very brief in my remarks. I think you really recalled the importance and the practical importance of these conventions, because they are really core pillars of the HCCH framework supporting transnational litigation. There's maybe one aspect I can highlight. I was interested and pleased to hear in the context of the last Special Commission meeting that the number of cases that went through the central authority system of the Service Convention had increased by 20% between 2013 and 2021. So we are talking about almost 44,000 requests for service abroad that went through a central authority system in 1 year alone in 2021. So that clearly shows the practical importance of the Service Convention in particular, but the same applies to the Evidence Convention. And these figures are based on the reported cases. So the numbers that the central authorities shared with the PB, but they are far from complete. So the actual figures are no doubt even significantly higher. I also like to say, also as a follow-up to our discussions that we had at CGAP, Council of General Affairs and Policy earlier this year, that the handbooks are very often used by practitioners, and they are also referenced in various court decisions, including in some decisions coming from the highest courts, Supreme Courts of some states. So that, I think, clearly shows how authoritative these handbooks are, and how visible they are also in the respective judicial community. And they are also our best seller. We sell quite a bit of these handbooks, and they are, of course, a welcome additional revenue for the organization, and we shall certainly continue to do so for at least 1 year, now that we have a new edition, and CGAP next year will discuss the financial impact of these handbooks again. But I also want to recall what Minho said, that this is really the result of a collective effort, and I personally know how much efforts are needed and go into the production of these handbooks. I worked myself on one of the previous editions, so I know what it all means. So I really want to extend my sincere thanks to the experts of the working group that joined the Permanent Bureau in developing these revised versions. And I thank in particular the chairs, Mr. David Cook from the United Kingdom for the Service Convention, and Mrs. Aldana Rohr from Argentina for the Evidence Convention. It was really a superb collaborative effort. And I do want to go on record also and thank the team at the Permanent Bureau, especially my colleague Melissa Ford and her colleagues, part of her team, and including secondees from Hong Kong and Korea, and many, many interns who have also contributed to this work. But I do want to take also this opportunity and particularly thank our Korean secondees who have contributed to this work, because it is a long-standing effort. So let me warmly acknowledge, among others, Judge Se-Young Park, Judge Jung-Ah Lee, and indeed Judge Min-Ho Do for all your most valuable contributions and bringing your valuable perspectives to these texts. So as was mentioned, these fifth editions are very rich in practical insights and guidance on IT integration, which is really a key topic throughout both these handbooks. They will be published next month in e-copy and hard copy via our new e-sales platform. There are still a few little things here and there that need to be finalized, but in July, these handbooks will go on sale, and they will, I'm certain, remain essential tools for the international legal community. So it gives me great pleasure to commend these handbooks to you today. Thank you.
Thank you, Secretary General. Now the Secretary General will unveil the physical copies of the new handbooks for the fourth time. Please give a big hand of applause.
Minho, please come and join me to do that. Give your phone to Jerry. Jerry will take pictures and we'll do this together. Much more significant.
Next, we'll proceed with the pre-order application. On behalf of the Judicial Policy Research Institute, we would like to invite Presiding Judge Kyu-Hong Lee, a chief researcher at JPRI, to the stage.
It's a great pleasure to pre-order these meaningful handbooks. Firstly, in the world, I believe that these handbooks will be of great value to our judiciary. Thanks.
Thank you. I would like to kindly ask Dr. Bernasconi and Judge Lee to take their seats for the signing ceremony. We would now like to invite the Secretary General to sign each copy of the handbook and Judge Lee to sign the pre-order application form. Yeah, thank you very much. We will now proceed with the exchange of the signed handbooks and the pre-order form. May I kindly ask you to rise and step forward to the table? Yes. At this time, we would like to ask you to exchange the documents and pose for a commemorative photo. Thank you very much. This concludes the handbook launch ceremony. We'll now take a 15 minutes break and then we'll proceed directly to session 5. Thank you. Distinguished guests, session 5 will begin shortly. Please make your way to the conference hall and take your seats. Now, I would like to invite the moderators, speakers, and panelists of the session 5 to the stage. Thank you. Ladies and gentlemen, now we'll commence session 5. In session 5, we'll be deal with regional perspectives on the use of IT in implementing the 1965 Service Convention and 1970 Evidence Convention. With the rapid advancement of IT, Korea, as a contracting state to both conventions, is increasingly confronted with practical questions concerning the use of electronic means, such as e-service and the electronic taking of evidence in the implementation of these instruments. This session is expected to offer valuable guidance on how these challenges may be effectively addressed in practice. It is my pleasure to introduce the moderator for this session, Presiding Judge Kyu-Hong Lee, Chief Researcher at the JPRI. Judge Lee is a recognized authority in international intellectual property and private international law, having made significant contributions to both academia and legal practice. Ladies and gentlemen, please greet Judge Lee with a warm round of applause.
Good morning, distinguished guests, colleagues, and participants. It's my great honor to welcome you to Session 5 of the HCCH Asian Pacific Week 2025, sorry. My name is Ki-Hong Lee, and I have the privilege of serving as the moderator for this session. As you know, the title of this session is Regional Perspectives on the Use of IT in Implementing the Service and Evidence Conventions. As you know, both the Service and Evidence Conventions have long played a fundamental role in facilitating mutual legal assistance across borders. Going further on the point, as the rapid increase in the use of IT technology triggered by COVID-19, IT in implementing these conventions offers significant opportunities to enhance efficiency, transparency, and accessibility, while also presenting certain practical and legal challenges. As I understand it, the request and the execution of a service and the taking of evidence, communication between the relevant authorities, and even the transmission of documents themselves can now be carried out electronically. We are also seeing cases where evidence is taken via video link thanks to advancements in audiovisual technology. Beyond that, IT is also being used or holds great potential in many other aspects of the conventions, such as electronic signatures or seals, case management, and payment of costs. I believe the possibilities are virtually limitless. In today's session, I am confident that each of our panelists will share valuable insights on how IT is currently being utilized in their respective jurisdictions and how these practices may be further improved in the future. After we hear from all four speakers, time permitting, we will open the floor for questions and comments related to the presentations. Now, let's begin with our first speaker, Ms. Krista Stanford. Ms. Stanford serves as Judicial Assistance Counsel and manages the Office of International Judicial Assistance within the Office of Foreign Litigation at the United States Department of Justice. Now, I would like to invite Ms. Stanford to begin her presentation.
Hello. Okay. Today, jujitsa 감사합니다. That is the extent of my Korean. But good morning, distinguished colleagues. It is my pleasure to be here. Thank you very much for the invitation and the opportunity to speak today. As the distinguished moderator noted, my name is Krista Stanford, and I've worked in the U.S. Central Authority for the last 9.5 years. And I'm looking forward to taking the next few minutes to walk through how the United States uses technology in the implementation of these two very important instruments. In my limited time, I plan to cover these topics to help give an understanding of how the U.S. leverages technology in the implementation of the conventions, as well as some challenges we have encountered, and some suggestions for improvement in the use of IT to further our goals with these conventions. A little bit of background about the Office of International Judicial Assistance, or OIJA, because the Office of International Judicial Assistance is a mouthful, and US government attorneys do love our acronyms. The Department of Justice's Office of Foreign Litigation is the office within which OIJ sits. And OFL supervises and directs all civil and criminal litigation in foreign courts where the United States is a party or otherwise has an interest. And then within that relatively small office is even smaller office, OIJA. And we serve as the central authority for the 1970 Evidence Convention, the 1965 Service Convention, the Inter-American Convention on Letters Rogatory, and for service and evidence requests that we receive through diplomatic channels for civil and commercial matters. OIJ is currently comprised of 2 full-time attorneys and 2 support staff. So we, like I said, are a very small office. I think it's important to start with a brief overview on the US perspective of service and evidence because, as I've learned over the last several years, is that the United States has a different approach to both service and evidence than many other countries in the world. First, service of legal documents and evidence gathering are not viewed as sovereign functions, which leads me to my second point in that there are legal mechanisms by which evidence can be obtained or service can be effected without going through formal channels, which means you can do both of these things without necessarily coming through my office and the US as the US Central Authority. You can obtain evidence from witnesses on a voluntary basis without seeking permission. And you can also serve documents on persons who will accept those documents voluntarily. Third, it is important to note that OIJ plays no direct role in outgoing evidence and service matters. So we do not review outgoing letters of request. We do not transmit them. We will provide basic guidance, and we provide extensive guidance on our website to help instruct litigants both in the United States and abroad, but we don't actually work on those requests directly. Turning specifically to the Service Convention, I thought it was important to highlight sort of 4 areas on how it operates in the United States. So since 2003, the United States has delegated the Ministerial Act of Serving Documents on private individuals and companies to a private contractor. Currently, that contractor is ABC Legal Services in Seattle, Washington, and that contract was just granted earlier this year, so they will be our contractor for the next 5 years at least. As a practical matter, this means that OIJ does not play any role in the actual execution of those requests. Instead, we oversee the contract, and we provide advice to ABC Legal if they have issues, or can provide general guidance or help resolve issues, but we do not play a role in the day-to-day execution of service requests, with the exception of service requests on the US government. Those requests do come to my office, and there has to be an exception to every rule. So you will hear me go on and on today about how much I love electronic transmission of requests to OIJA, except if you want to serve the US government. Those have to come in hard copy. We can't accept those by email. So I think that's important to note because, of course, there has to be exception to every rule. My second point is that the United States has not objected to the alternative methods of service under Articles 8 and 10. As a practical matter, that means that you can arrange for service directly through process servers or other individuals or competent authorities to serve under the domestic US law. Because the Central Authority doesn't play any role in that method of service, we do not have any insight into the number of documents that are being served through those methods. We do, however, have insight into how many requests we're receiving through Article 5 or the so-called main channel of transmission. On average, ABC Legal receives about 7,500 requests for service under the 1965 Service Convention under Article 5 per year, which is not insignificant. And it's a large reason why we have to use a contractor to execute those requests, because 2 attorneys and 2 support staff could not handle that level of requests. Lastly, I wanted to point out that in 2024, ABC Legal received approximately 26% of the 1965 service requests it received electronically, and that would either be through email or through their online platform, as I'm going to talk about in just a moment. As I just observed, the majority of requests are still coming to ABC Legal by paper. However, the mechanisms exist to have a fully electronic process in the United States for the transmission of the service request and to the United States and the transmission of the certificate back to the requesting authority. The request can be submitted either through the online platform or by email. But the benefit to the platform, as we'll see in a couple slides, is that it allows you to do everything in one place. So you can upload your documents, you can make the necessary payment, you can receive status and progress updates, communicate with ABC Legal staff, as well as obtain the proof of service, all through the platform directly. And as a side note, I do want to mention, for those of you who might not be aware, it does cost $95 to serve under the 1965 Service Convention in the United States, and that is to cover the cost of the private process servers that go out and personally serve the documents. Which brings me to my last point on this, and I do want to make the very important distinction that when I am talking about transmission of the documents, I am truly talking about transmission of the request to ABC Legal. ABC Legal does not serve documents by email. All service requests are executed through personal service. Email service is not something that is readily available under US law, and so it is not a way that we are going to be executing service requests. So this slide shows a screenshot of ABC Legal's platform and how you can upload a request and submit the request electronically. As you can see from the right-hand side, it gives the order summary and the total. And so one of the strongest benefits, I think, of this platform, in addition to having everything in one place, is that it ensures that that $95 fee is going to be paid because it won't let you submit the request without that payment. And for requests that are received by email and requests that are received by paper, that is one of the main reasons why ABC Legal has to return requests unexecuted, is for that lack of payment. Then, once you submit the request, the user has access to the ABC Legal dashboard. Here you can see that the user can track the status of the request under the status updates and activity. It will give, as process servers go out and make multiple attempts, each of those attempts will be outlined in the status updates and activity. And then once the proof of service has been signed, it will be available for download. So the user can essentially get real-time access to any of the documents, meaning that you get your proof of service faster, you can submit that back to your court, and your case can move on more quickly. There's also the support function as well, so you can chat, and the ABC Legal staff will use that to follow up if, let's say, the form is missing something, or there are translations missing, or there are other deficiencies that would otherwise mean that they would have to return the request unexecuted. They can reach out through that support function and ask for the request to be remedied so that they do not have to return it unexecuted. Turning now to the evidence convention. I want to start with, we receive on average 500 requests per year. This is both, that number does include both the requests we receive through diplomatic channels. However, the large majority of requests do come through the 1970 Evidence Convention. And as a practical matter, we treat requests that come through diplomatic channels the same as we do for those that come through the Evidence Convention. In the last 5-6 years, we have changed our processes dramatically, and now 80% of requests are handled internally by OIJA. This means that they never leave our office, and one of two things will happen. Either one, my office goes out and we obtain the evidence. We will contact witnesses, obtain bank records, obtain testimony, whatever it is, or the request is returned unexecuted. either because it's somehow deficient under the convention or US law is preventing us from executing the request. The remaining 20% are executed with the assistance of US attorneys' offices throughout the United States. This is usually for requests that require court orders in specific jurisdictions, such as the Northern District of California. All of our Google, Facebook, Meta, all of those requests go to the US Attorney's Office in the Northern District of California because they have the connections with those companies, and I don't want to have to file 1782, which is our judicial assistance statute, proceedings in California. So those we do use the US Attorney's offices, and we also use US Attorney's offices for DNA samples. As a consequence, when we're working with US Attorney's offices, those requests will take a bit longer to execute than our requests that we can handle in-house. Because this is our #1 priority, and for the US Attorney's offices, this is not their #1 priority. They obviously have their own cases that they're handling. In 2024, I was very pleasantly surprised to see that 41% of requests were received electronically through email, which is a very large majority as compared to what we're getting for service requests. I will note that I think that's because there are certain key countries that submit a lot of requests to the United States and they send everything to us electronically, but we do want to keep encouraging requesting authorities to transmit those requests to us by email. And lastly, I do want to note that most of our executable requests are completed on a voluntary basis. And this means that we can execute these requests quite expeditiously, generally in less than 3 months. I hope that that number stays the same, although I have recently learned that my paralegal will be leaving. So we will soon be 2 attorneys and 1 support staff. And so apologies if our execution time gets a little bit longer because of that. Over the last 10 years, we have really learned how to leverage technology in the implementation of the 1970 Evidence Convention within OIJA. And since the pandemic, we have very much transformed our processes to be almost entirely electronic within the office. So we can track our cases, we have improved our processing times, and we have improved our communication by being able to use those electronic methods, primarily email. And we also had the development of a custom-made proprietary database that tracks all of our incoming requests. This database has been in existence since before I was in the office. However, because it was made for our office, we have been able to tailor it and make changes as time has gone on. So here's a screenshot of FIRMS, or the Foreign Evidence Request Management System. And it was specifically designed for OIJA. And whenever we have developments in how we're processing things, if we want to make any changes, we just contact the developers and say, we need to do X. So during the pandemic, we added this category function that you can see, and there's where we can note if a request comes in by email. The database allows us to run, as you can see on the left-hand side, some standard reports and searches, but then we can also custom build searches as well to be able to run analytics, metrics. When the Permanent Bureau asks us for data, I can run searches and sort of parse out what I need to answer the questions that we get asked. The other really important development that we had in the last few years is that we added this ability to send action items within the system itself. So the entire management of a case is done through these action items where a request is added to the system and I will assign it to someone for processing through an action item. So we're doing everything internally within a single system and not having to worry about emails telling somebody to do something or going down the hall and things falling through the cracks that way. It was hard to narrow the benefits to firms because I feel strongly that the database has been very helpful to us, but I brought it down to 5. First, it allows us to identify resubmissions and related requests. Each request does get a designated DJ number or a Department of Justice reference number, but those requests will be cross-referenced. So if it's a resubmission of a request that we had a witness send us back the answers by email, we can identify that and we'll send the new request to the witness by email and ask them to respond. And that way we're not sending things by FedEx, and it's cheaper and faster to get those requests to the witnesses. We can access all of our case-related documents, including scans of the letters of requests. If we receive a request electronically, no one has to scan it, which is great, as well as any correspondence, all of our letters, and everything is available through a click of a button through firms. As I mentioned previously, we can search records, and within the database itself, we can track the status of requests as well. And usually on a monthly basis, will do a review of all of our pending cases, which at any given time is anywhere between 80 and 120 pending cases. And I will make sure that the statuses are up to date, that there's nothing that needs follow-up, that an action item wasn't lost, and to really help prevent things from falling through the cracks. And we can also manage our workflow, again, through those action items that I talked about previously. The use of technology has brought a lot of benefits, but it's not been without its challenges. And I highlighted 3 challenges here that I think have pretty simple solutions. First, voluminous requests. Voluminous requests. Why are they a problem? Well, as a practical matter, when it comes to actually executing a request, they give me a headache because I'm always concerned that I'm going to miss important, valuable information that may be buried in page 300 of a 500-page document. As I noted, we get 500 plus requests a year. We're a small office. We don't have the capacity to read a 500-page request. And the convention is very limited in the requirements of an evidence request and what is needed. So we don't need all of those documents. But from a technology perspective, it's even more of a problem. If we receive those large requests, they can't be transmitted to our office by email. We do get some requests through online, Google Drive or those sorts of downloading software. But I know from some of my other central authority colleagues, they don't have the ability to access those sorts of online databases when they're commercial products because of security reasons. So that's an issue. If it's too voluminous, but somehow they can still figure out how to get it to us, it's really hard to print to give a copy to the witness. And again, you're not going to have a witness who wants to read 500 pages. We want to encourage witnesses to provide this evidence voluntarily. We don't want it to be a burden of, here's 1,000 pages to please read before you answer these 5 questions or whatever the case may be. And then lastly, and probably most annoyingly, is that when they are sent in hard copy, somebody has to scan that. And we get them and they're ribboned and bound and they've got staples and lots of staples. And all of that ends up adding time to our processing procedures. Because if we receive 500 requests that have 50 staples in them, that's a lot of time removing staples. And most recently, we actually received a service request from the US government that was bound like a book. And my paralegal got it and she was like, I don't know what to do with this. Like, how do I scan this? And we had to bring it to we have a copy room, and they're like, can we take it apart? And I was like, please take it apart so you can scan it because we need that electronic copy for our records. So please don't send things bound. It's not great. So I think the solution here is easy, right? It's ask, what are the documents that are absolutely necessary to be served? What are the documents that are absolutely necessary for the witness to see and for the convention to be complied with? And for the convention to be complied with, you don't need a lot of documents. We get requests that are like 4 pages. And we're like, cool, we're good. We got all the information we need and we can go out and execute it. So asking those questions before submitting a request can really be helpful. Second, the inability to contact unresponsive central authorities and requesting authorities. This is a problem because I really hate returning requests unexecuted. I want to do everything in my power to not do that. And so if it's something that's easy that can be fixed, if I know I can send an email and receive a response, I will do that. So we recently had a request that was missing a translation. So it had come in by email and we responded back to the judge and we said, we need an English translation before we can act on this. And within a week we had an English translation. We were able to open the case and proceed with executing the request. When we have requesting authorities or central authorities that we know are not responsive, honestly, at this point, we don't have the time or the bandwidth within our office to be chasing down responses. So those requests just get returned unexecuted. And it's a shame because it is something that we would be able to act on if that one small question was answered. But we don't have 6 months to wait for a response. And so we have to return it unexecuted and say, please resubmit with X, whatever you need, the translation, the questions for the witness, whatever it might be. So I think it's really important, again, a simple solution. Encourage inclusion of accurate contact information on country profiles and in requests if it's not going to a central authority, if it's going directly to the requesting authority, as well as timely responses to inquiries. And again, and I'm going to talk about this in a second on another slide, but if an inquiry is sent and says, I need an English translation, if the response comes back and says, right, thanks, so sorry, we will, it's going to take us 4 weeks to get you an English translation, or it's going to take us 8 weeks to get us an English translation, I'm not going to go and return a request unexecuted at that point. It's when things go into a black hole of a vacuum and I never receive a response that, our hands are tied and we can't really do anything. Lastly, we see a lot of inaccurate addresses for witnesses within requests. And this is related to technology as well, because we have very limited abilities to do searches for witness addresses within the United States. And if a request has sufficient identifying information, we will leverage those online databases to try and locate an address for the witness. However, what we would actually encourage requesting authorities to do is try and contact those witnesses in advance. As I noted before, evidence gathering is not viewed as a sovereign function in the United States. There's no objection to requesting authorities, foreign counsel, litigants from contacting witnesses in the United States to confirm that you have the proper contact information, that they're willing to provide the evidence voluntarily, and just giving them a heads up that they've been named as a witness. The number of requests we get where the witnesses are like, what's going on? I haven't talked to those people in 15 years. I don't understand. And having that information from the get-go in the request, and then if the request can include an email address or a phone number for the witness, that means that our office can be working on obtaining that evidence that much faster. And I do want to note that, just to make one quick distinction, there's a distinction between contacting a witness and asking for them to voluntarily give evidence and any sort of foreign compulsory process that is purporting to compel a witness in the United States to provide evidence in a foreign trial. That would not be permitted. We do view that as a violation of our sovereignty. But if it's simply contacting for involuntary purposes, that is perfectly okay in our book. Lastly, I have 2 suggestions for improvement, as you might be able to guess from the rest of my presentation. First is going to be increased communication. Acknowledge receipt of inquiries, even if updates can't be provided immediately. I have really had some situations where I've really wanted to tear my hair out when I've been trying to facilitate getting status updates on requests and just no response whatsoever. And again, sometimes when we get status inquiries, all I can say is, yes, we received it, no, nothing has happened, but I would be happy to tell you that. And we actively encourage litigants and requesting authorities to contact our office and seek status updates. Because if we haven't received the request, I would rather know. It just happened the other day where we received a status inquiry in the mail of a request that had purportedly been sent to us a year prior, and we had no record of it. And if somebody had followed up, after a month of not receiving an acknowledgement letter, we would have been able to say, oh, hey, we never got this request. Please send it to us by email. Please send a new copy. Please get it to us and we'll happily go and obtain the evidence. And then lastly, on this point, is just to provide timely substantive responses to central authorities and requesting authorities that are seeking assistance to help make the process move that much more efficiently. And again, I can't emphasize enough that we do encourage the electronic transmission of requests. It leads to faster resolution of requests. It lowers the risk of requests being lost. And I do know, after speaking with my colleagues last year at the Special Commission, there are a lot of restrictions on using electronic transmission, and for some countries, it's still required that those physical documents have to be sent. And in those cases, we would encourage sending a courtesy copy by email in advance, because the second we receive the courtesy copy, we are going to be opening a file and we're going to be starting to work on that request. And if it's something that there's information missing or something we can't execute, the requesting authorities are going to just know that much faster than waiting a month, 2 months for everything to arrive in our office in hard copy. Thank you very much.
Thank you. Thank you for your sharing invaluable insights and giving detailed and practical explanation and even suggestions. Thank you very much. United States' active and effective use of IT was truly impressive. We will now move on to the second presentation. This time, Mr. Chao will introduce the practice in China. Ms. Chao is with the International Legal Cooperation Center of the Ministry of Justice of China. Ms. Chao, if you're ready, the floor is yours.
Hello. Dear colleagues, it's a great honor for me to give a speech at this conference. I'm Cao Juan from the Ministry of Justice of China. The topic of my speech is the use of IT in implementing the Hague Service Convention and the Hague Evidence Convention in China. The Ministry of Justice of China is the central authority designated by the Chinese government to implement the Hague Service Convention, the Hague Evidence Convention, and 39 judicial assistance treaties in civil and commercial matters. At present, the IOCC, under the Ministry of Justice, performs the function of the central authority in charge of judicial assistance in civil and commercial matters. With the growing international exchanges and cooperation, the number of civil and commercial judicial assistance cases handled by our ministry has been steadily increasing year by year. On average, over the past 5 years, it has reached being more than 3,000 cases annually. It demonstrating a sustained upward trend. In order to enhance the efficiency of processing judicial assistance requests, reduce enforcement costs, and align with the global trend of leveraging information technology in legal matters, our ministry has officially launched an online submission system accessibly at www.ilcc.online. Our system started trial operation in 2019 and was officially launched in 2022. It enables foreign requesting party to submit requests for judicial assistance online, while our end is responsible for receiving, reviewing, and responding to these requests. Currently, nearly 30 countries and regions utilize this system. According to the data printed in the chart, the United States and Canada are the most frequent users. Cases submitted via the online system constitute 1/3 of our total case volume and exhibit a steadily increasing trend. In recent years, we have established and maintained exchanges and cooperations relationship in the field of judicial systems with over 60 countries and regions. Therefore, we're particularly eager to encourage more foreign requesting parties to submit cases through our online system. The system is highly consistent with the strategic direction of Digital China and a smart government. Meanwhile, it fully demonstrates the new development philosophy of innovative, coordinate, green, open, and shared development, and also provides innovative solutions for international judicial cooperation and the optimization of the business environment. In addition, the system also conforms to the global trend of judicial digitalization, which is conducive to strengthening international judicial exchanges and promoting the development of global legal cooperation towards a smarter or more transparent direction. The development of this system not only reflects China's leading practice in the field of digital governance, but also contributes Chinese wisdom to build an open, inclusive, and convenient international law environment. Next, I'll introduce our system to you all through 3 key aspects: how to submit a case, and the system functions and advantages. To start with, how to submit a case. When you access the system's login page, you can click on the Sign Up Access. Yes, this Sign Up Access to impart the registration details. Then access the system login page, enter the email address, password, and click on the login button. Once logged in successfully, navigate to the home page and simply click on the Submit button, this Submit button, to add a new case. As shown in the screen, in the pop-up dialog box, choose Civil and Commercial Matters, and then proceed by clicking Next. Reading the notice, and click Agree and Next. Now, you need to choose the case application types. We select Apply Online here, as its operation process is the most complete. Also, if you have completed and signed Hague forms, please directly upload the signed form and the document to be served here. You select OK, Next button. The following are the main body of case submission, including 5 steps: basic information, request form, summary of document, upload, and submit. Then enter the interface of adding case. You need to select legal basis, country, and the subject matter. Select the Hague Service Convention here, for example, and select the country, the course of action. When finished, you can click on the Next button. The interface is shown below. Now you need to fill the Hague request form, including entering the identity and address, selecting the method of service, and filling the list of documents. Here, you can click on the download button, or click Print and Sign to preview and print online. Once all the above is completed, click Print and Next to proceed to the next step. One more thing worth noting is the entrance at the lower right corner of the page. Click the Save as a Template. You can save the information you entered before as a template for future use, allowing you to easily reuse it next time. Let's move on to the third step, summary of document. In this part, you need to fill the name and address of the requesting organization, the details of parties, the judicial instrument, and the judicial or extrajudicial document. Here, you can download the summary or click Print and Sign to preview and print online. As the form is accomplished, you can click Download button to download the summary or click Print and Sign to preview and print online as above. Next, it's time to upload your files. Just click the Select Files to pick your document up. Once everything uploaded, click Submit to write up. That's the final step. Now, the submission is completed. You can get the case number, this case number about CNAs. Keep this number handy, which is crucial for following up execution process. In addition, our online submission system has many practical functions, such as list of cases and help. In the list, you have the options to search, edit, delete, cancel, resubmit cases, and view details. Like this. Considering the number of cases submitted by users online will gradually increase, the system offers a search function based on keywords for users. To provide with users a better using experience, we have set up a help zone in the system here. When you encounter problems during use, you can refer to the question and answer and operation manual or use the online consultation function. Lastly, I'd like to present the advantage of our system. The first is cost reduction and efficiency improvement. After requesting parties submit the judicial assistance cases to our department through online system, including the subsequent supplementary materials, it is not necessary to provide a paper version, which greatly reduces the mailing cost for the requesting party. Furthermore, processing outcomes are communicated through the same online platform, thereby enhancing execution efficiency. As we can see in the screen, that cases submitted online take only about half a month at the fastest. Secondly, the case handling process is traceable. For cases submitted through our online system, the requesting party can monitor the process of the case handling in real time. Additionally, the entire process is transparent and fully traceable, ensuring accountability and clarity at every stage. Thirdly, the system security is guaranteed. Our system construction complies with the standard of data security. Every year, we start security assessment and risk screening and attach great importance to the confidentiality management of data. Fourthly, it is user-friendly and provides considerate service. The system interface is designed in a simple way, which is easy to operate. Meanwhile, the system supports the request party and our central authority to communicate at any time regarding a specific case. Once we discover problem during the review process, or the requesting party have materials that need to be modified or supplemented, the dialog box, this dialog box allows us to communicate instantly. The system has been proved to be a reliable and a rapid way to keep on cooperation in international judicial systems, especially in the post-pandemic era. It saves time and money as the requesting party are not asked to send the hard copies to our office by international mail or couriers once online submission is completed. We sincerely invite you to use the online system to submit any request for judicial assistance in civil and commercial matters in the framework of Hague Service Convention, Hague Evidence Convention, and bilateral treaties between China and the foreign countries. To get started, please visit www.ilcc.online and begin using the system. We hope to see your request in our system very soon. Thank you.
Thank you. Thank you for your presentation. Through it, we can understand the listen Chinese system in detail. Thank you again. And your system is likely to inspire many other countries. So the presenter is Ms. Huang Ho Pham from Vietnam. Ms. Pham serves as the Deputy Director General of the International Law Department at the Ministry of Justice of Vietnam. She has played a key role in a wide range of important matters in the field of private international law, including those related to the HCCH in Vietnam. And she has also been actively engaged in academic work, authoring numerous publications. Well, let's give a round of applause and invite her to begin her presentation.
Good morning, everyone. It is my honor to be here today to share with you some aspects of civil judicial assistance in Vietnam. And first of all, I would like to express my sincere thanks to the host and the HCCH for organizing this wonderful forum. Give us the chance to share and to learn experience from different countries. And to join you, I want to provide you some information about our practicals in civil judicial assistance in Vietnam. To start, I want to show you an overview of our legal framework. You can see that we have joined the service conventions in 2016, and in 2020, we joined the Checking of Evidence Convention. Besides, we also have 17 bilateral international agreements. About domestic legal basics, we have a law on judicial assistance, which combines both civil and criminals. But in that, we have a specific sections on civil judicial assistance and some guiding normative, legal normative documents. We also improving our relevant legislations to ensure the consistencies of our legal systems. For example, the civil procedure cost and ordinance on the court fee to meet the requirement of the international agreements. So together with our comprehensive legal framework, we also implement many enforcement measures, including issuing documents and materials like the handbook and training course for the local competent authorities. We also periodically reviewing, evaluating, and supervising the execution of the requests both in and out. Our governments have the report to the National Assembly every year. We also try to establish and enhance the direct contact with central authorities of foreign countries. So with our efforts, we from 2008 and to 2024, we received and execute more than 55,000 requests, and we received nearly 33. Sorry, I have sore throat. And we received nearly 33,000 response. I want to show you the tables. Oh, can you open it for me? Yeah. This is a table of data of civil judicial assistance executions Vietnam from 2008 to 2024. And you can see that. Yeah. We joined the Service Convention in 2006, and then we implement, and from that the results of response increasing. And the time is shorter, just about 3 to 4 months for response. Before that, it takes nearly 1 year. So about the application of information technologies. So in Vietnam, we develop and operate a very simple software for managing and executing civil judicial requests, but just within the central authority only. We use it to handle the key files on software and for the collecting information of civil judicial requests for purpose of monitoring, searching, compiling, and analyze. Then I want to show you some pictures of that software. It's very simple, but we can see the competent authority who send the request, our domestic competent authorities, the number of officer departs, yeah. So this we use to search the informations. It's very simple, but it helps us save time. So you can see, we can find the requesting countries. In the days, we receive Yes, this software is very simple, but we also improve it in the future. Besides the software, we also send document and receive response by emails with some certain countries. So here you can see the top 10 countries that we have sent and received requests. And with the China and United States, we can exchange the request and receive the response through emails. You can see. This is numbers of requests sent from Vietnam to foreign countries. The majority of our requests are service of documents. But we also receive some requests for correcting evidence online from some countries like Singapore, Korea, Philippines, and Poland. However, our domestic laws do not govern this kind of requests, so we could not provide assistance. But we do not object if the requesting states take the evidence of their own citizens and within the embassy's office. And to improve the effectiveness of the civil judicial assistance work in Vietnam, we had planned to adopt a new law on civil judicial assistance. And yesterday afternoon, this law was discussed in our National Assembly and received high support. And we hope that it will be adopted in October of this year and take effect in June of 2026. And in this new law, we provide very comprehensive legal foundations for conducting civil judicial assistance procedure through electronic means. So here, I want to show you some article of the new laws which provides regulations on IT's executions for out and in the request. So together with our legal framework, we also have the project to develop a news information system for civil judicial assistance. It aims to build a comprehensive web-based platform to manage the entire process of civil judicial assistance, which including request submissions, transfer, receipts, and execution. And this project expected to finish in 2028. So from our practice and experience, I would like to have some recommendations as follows. We think that civil judicial assistance must be more efficiency, rapid, and comprehensive to align with the demands of international cooperation and to strengthen the protection of human rights in the judicial areas. And to achieve this goal, it is needed to enhance cooperation and information exchange among central authorities and the evaluations of lessons learned in order to improve our implementations. The request executions methods must be modernized and more flexible, particularly through the adoption of ITs, digitalization of procedures, in response to the very fast-growing IT revolutions recently. And we also think that the domestic legal frameworks need to be complete to support and to recognize the legal values of digital processes. And infrastructure development systems, synchronization, and enhanced IT connectivity, both among the domestic competent authorities and among the central agencies of member states, are very important to achieve those goals. And to conclude my presentations, I want to say that HCCH play a very important role in unifying procedures and creating a global connection platform for member countries in implementing electronic civil judicial assistance. And we do hope that HCCH and the permanent bureaus continue to strongly promote the project on e-service and e-evidence as it meets the needs of applying IT in executing civil judicial assistance in member countries. Thank you so much for your attention. 감사합니다.
Thank you. Thank you very much for your insightful presentation. We were able to see that Vietnam is also making multi-use of IT in implementing the conventions. Especially, I think the recent information and excellent software system is very impressive. Now we will proceed with the final presentation. Our last presenter is Judge Sung-hoon Koo from the Republic of Korea. Judge Koo is currently serving at the Yeongwol branch of the Chuncheon District Court. I would like to invite Judge Koo to begin his presentation. Let's give him a round of applause.
Hello, everyone. I know it's almost lunchtime. I see the faces of hungriness all here. I promise I'll make it concise and brief, and I will not make you guys hangry. Hello, my name is Sung-hoon Koo. I work as a judge in South Korea from Yeongwol branch. Today, I'll discuss how information technology, here and after IT, is currently being utilized in Korea concerning the Hague Service and Evidence Conventions. First, as a starting point, I'll delve into the current practices in international service and evidence request in Korea. Currently, there are 4 methods, primary method used in service or evidence requests. And these are: first is the request under the 2 Hague Conventions. Second is the request based on bilateral treaties. Korea has concluded 5 bilateral treaties with Australia, China, Mongolia, Uzbekistan, and Thailand. And third is the request via consular channels. And fourth is the request through competent courts, the foreign competent courts, about the detailed procedures. I'll get back to these later. I'll now proceed to explain the detailed procedures for service and evidence requests. For the requests under the Hague Conventions or bilateral treaties, the procedure is identical, as you can see in the slide. The detailed procedures are as follows. For the first step, the presiding judge at the court prepares the request documents. They print it, they send them to the postal mail to the NCA, the National Court Administration, which serves as Korea's central authority. As a second step, the NCA compiles and forwards the printed documents to the Foreign Central Authority through postal mail system. And third, the Foreign Central Authority then executes the service or evidence collection. So as you can see, the whole process is handled through printed documents in hard copy. For consular service requests, the procedure is as follows. First, the presiding judge sends the printed request documents to the NCA, then the NCA forwards them to the Ministry of Foreign Affairs of Korea. And third, the documents are dispatched via diplomatic pouch to the relevant Korean embassy or consulates, I guess by DHL or FedEx, which then carries out the service. As we can see here, service or evidence are predominantly requested by printed documents, and IT is not widely incorporated in Korea yet. And since request by the consular channels takes about 4 to 6 months at least, request through postal mail takes a lot longer time. This is being pointed as one of the contributing factors to the delays in judicial proceedings in Korea recently. We'll get to the statistics. Among the 4 methods I mentioned, the consular channel is most frequently used, as we can see, with approximately 4,000 service request cases annually. Requests under the Hague Convention average about 750 cases per year, while those based on bilateral treaties account for around 250 cases per year. Direct requests to foreign courts are relatively rare, averaging only about 80 cases annually. The consular channel is most frequently used because it is procedurally simple and can be handled quickly. It is widely used when the recipient is a Korean national or the service location is in the United States. About the statistics on the evidence request, in comparison, evidence requests are less frequently made than the service requests. Over the past 3 years, Korea has received an average of 50 evidence requests annually and has sent about 30 such requests to foreign countries. As we can see here, the volume of service requests significantly exceeds that of evidence requests. More specifically, in the year 2024 alone, there were a total of 4,290 requests for service of documents and 139 requests for the taking of evidence. And among the 4,290 requests, 3,291 were carried out through consular channels. It accounts for almost 80%. 701 under the Hague Service Convention, 247 based on bilateral treaties, and only 51 through letters of request to the competent court. As for the 139 requests for the taking of evidence, 72 were conducted through consular channels, 38 under the Hague Evidence Convention, 6 based on bilateral treaties, and 23 through the letters of request to the competent court. About the challenges. We'll now turn to the challenges and the potential improvements regarding this issue. I have issued that IT has not been widely adopted in Korea as of now. The primary obstacle in adopting IT in the aforementioned process is the absence of explicit legal provisions in Korean domestic law permitting electronic methods such as email for the international service. Although Article 10A of the Hague Service Convention can be interpreted as permitting service requests by electronic postal channels, Korea made a reservation upon accession, objecting to this provision. Therefore, we cannot rely on that article either. Despite these challenges, there is still room for improvements within the existing legal framework in Korea. Korea has a very well-established electronic signature system, and by utilizing such system, judges can electronically sign the service or evidence request documents and transmit the electronic files without printing them. This approach could drastically reduce the processing time and also decrease the risk of document loss. However, it has to be noted that this method does not entail serving documents by email, but rather maintains the existing channels while sending an electronic file instead of a printed document. In specific, as in consular channels, the current process involves multiple steps, from the court to the NCA, then to the Ministry of Foreign Affairs, and finally to the embassy or the consulates. Each step takes days and even months by sending printed documents in hard copy. So by adopting electronic transmission, the electronically or digitally signed documents could be sent directly from the court to the NCA, to the embassy or the consulates within seconds. and streamlining the process. Korea has a domestic law named Act on the Use of Electronic Documents in Civil Litigations, and it recognizes electronically signed documents as the original ones. Although the system for electronically signing the request documents is not yet in place, efforts are being made and they're underway to develop the necessary infrastructure. It is actually a matter of time and cost, and the cooperation between the judiciary and the Ministry of Foreign Affairs is also necessary. Foremost, since the electronic signature system used by the judiciary and the Ministry of Foreign Affairs are different, we also need to focus on introducing a unified electronic signing system as well to send digitally signed file to the Ministry of Foreign Affairs. While the system is being developed, we can think of two interim measures. First one, we can use the official email accounts for the sole purpose of transmitting request files between the two institutions. And second, we could send the original electronic files to the judicial officers stationed at the foreign embassies or consulates, who would then process them through the Ministry of Foreign Affairs electronic approval system. In consular service requests, however, electronically signed request documents would be transmitted instantly from the court to the embassies or consulates once the new system is adopted. This would expedite the process compared to the traditional postal mailing system, and the judiciary is actively collaborating with the Ministry of Foreign Affairs to implement this system as of now. For the requests under the Hague Convention or bilateral treaties, additional coordination with foreign central authorities is necessary. The NCA is currently engaging in discussions with individual countries to facilitate the electronic transmission of electronically or digitally signed request files. And on this matter, we have received favorable responses from Australia and China recently. This is the last topic. Lastly, I'll briefly explain the procedure for the video testimony or the witness examination using IT. In the context of video-based witness examination, two methods are generally recognized. The first method involves submitting a request for witness examination who lives abroad to a foreign jurisdiction through the central authority, the NCA, under the Hague Evidence Convention. And the second method entails the court directly contacting the witness and conducting the examination via video link without the involvement of the central authority. The former refers to a case where the court requests an examination, whereas the latter involves direct examination by the court. The former method, the first one, is infrequently utilized as reflected in the statistical data. So as we can see, the video testimonies are very rare. From the year 2022 to 2024, Korea did not send any video testimony requests, as we can see, to the foreign countries, while receiving only a few such requests. In contrast, while the second method is understood to be employed more frequently, the specific data or the statistics are not readily available since the requests did not go through the NCA, the central authority. In practice, it appears that the courts prefer to conduct video witness examinations directly rather than going through the NCA. In 2016, the Korean Civil Procedure Act introduced a new provision, Article 327-2, stating that an examination may be conducted through transmission facilities using video or other devices or internet video systems such as Zoom, if the witness resides in a remote area, or if there are other circumstances that make it difficult for the witness to appear in court in person. Based on this provision, direct video witness examinations are more frequently being conducted at the international level as of now. The bilateral agreement between Korea and Australia expressly provides for the taking of evidence by means of video transmission, And there have been instances in which the United States and Australia have responded to the effect that where the witness voluntarily consents to participate in a video-based examination, then the examination may be conducted directly by the court without the involvement of the central authority. In my personal opinion, I think that if the location of the witness is known and the direct access to the witness is possible, then the examining court should conduct the video examination itself directly, since requesting a video examination with recourse to the central authority would result in a form of indirect examination. Direct video witness examination would enhance the procedural efficiency and the substantive due process. We're now coming to the end of my presentation. In this session, I have provided an overview of Korea's current practices regarding the use of information technology in international service and evidence requests, along with potential improvements that we have. I hope that the proposed enhancements will lead to more efficient judicial proceedings and better protection of each party's rights. Thank you once again for your attention, and I welcome any questions. Thank you.
Thank you. Thank you, Judge Gu. Thank you for your clear and informative presentation on the implementation of Korean Convention implementation. Now that we have heard from all four panelists, we will proceed to the Q&A session. Maybe the limited Q&A session because the time limits. Are there any questions or comments regarding the presentations we've just heard? It's very near to the lunch time. Because of time limit, unfortunately, we regret that we must conclude the session here. We hope that this session has provided meaningful IT technology support for the effective implementation of both the service and evidence conventions. Although the session has come to an end, we encourage continued discussion and exchange of ideas during the upcoming luncheon. I would like to once again extend my sincere thanks to our panelists for traveling from afar to share their valuable insights with us today. Please join me in giving them a round of applause. Thanks.
I appreciate for all participants of session 5 for such an in-depth discussions. This brings us to the end of the session 5. Luncheon will now be served at the restaurant just across the hall, the same venue as yesterday. As the session 6 will begin at 2:10 p.m. in this conference hall, so I would like to ask you to be back in your seats 5 minutes earlier before the next section starts. Please enjoy your lunch. Thank you. Distinguished guests, we're soon starting session 6. Please come into the conference room and take your seats. Now, I would like to ask the moderator, speaker, and panelists of the session 6 to take their seats on the stage. Thank you. Welcome back, everyone. I hope you enjoyed lunch. And we'll now begin session 6, the 2005 Choice of Court Convention and the 2019 Judgments Convention. The two conventions are the result of international efforts to establish uniform rules on jurisdiction and the recognition and enforcement of foreign judgments in civil and commercial matters. This session will provide a timely and meaningful opportunity to explore the legal and practical implications of accession to these conventions, particularly for jurisdictions like Korea that are not yet party to either instruments. It is a great honor to introduce the moderator of this session, Professor Gyu-ho Lee from Joohang University. He's one of the Korea's foremost experts in international intellectual property law and has served as the president-elect of ILA Korea and the Korean Association of Arbitration Studies and the vice president of the Korea Private International Law Association as well, and has conducted extensive research on cultural heritage and jurisdictional agreements in cross-border litigation. Distinguished guests, please welcome Professor Lee with a warm round of applause.
So to moderate that just after the lunch is not an easy job. You look like you're sleepy, but here, what the sum, the Sabbath stands for? The Sabbath is three, the light. And the sun is the island. So we will have the sunlight after lunch, and we have the one distinguished professor for the speakers, and 4 panelists for the honorable panelists. So please allow me to introduce this session's speaker. His name is Jang Jun-hyuk. And he is the law professor at the Seongyungan University. He used to work as the law firm law office called the Kim Jang, the largest law firm in Korea. Also, he used to work as a delegate to represent Republic of Korea, in terms of the 2019 Judgment Convention. So please, give him the round of applause. So you'll be given the 20 minutes. Okay.
Mr. Chairman, Professor Lee, thank you very much for the kind introduction. Just one correction. So I worked with Kim Jang and Lee. So I'm sorry about that.
Huge mistake.
But let me continue. Well, we have this wonderful group of distinguished experts here dealing with 2 very important and new conventions. My presentation would begin by sketching background, the broader background and the negotiation history, and then I would summarize only the framework. The most important thing probably could be jurisdictional filters, but panelists will be the real experts to discuss. So, and I think my role is to make a more transparent overview of the 2 conventions to Asian audience. So I would try to focus more on the framework and the structure. And also I will try to mention the challenges and possible benefits from the conventions with a particular focus on Asia-Pacific and a little more focus on Asia, particularly because there may be less participation in Hague conventions in broader Asia. So please excuse me for that aspect. So actually, we should begin by saying what is Asia. It is a difficult topic. Professor Zhao already mentioned. Professor Secretary General already mentioned it. But somehow Asian countries are grouped together as Asia. It just happened to be, I think. Asia is something, a kind of concept east of Europe, but outside Europe. So it's kind of a residual concept. And Asian identity is somehow given from outside. And interestingly, Asian countries tend to focus on the close neighbors. Oh, this is Asia, but looking at the map, Asia is broader and it contains all the diversities, not all, but many diversities existing in the whole world. So it means the huge diversity remains in Asia Pacific, and it may make things more complicated. But for private international law particularly, I think Asia Pacific is a rich ground for exploring the benefits, possibilities of private international law, and also a rich background for following the universalist approach. So I think it fits into the HCCH approach to harmonization. So how the judgments project in the larger sense developed? Well, as far as I understand, if I understand correctly, the United States had an initiative, and that initiative first directed to bilateral negotiations with the integrated Europe, but somehow United States side, particularly academics, decided that it would be better to be faithful to the universalist ideas. So as to do that, it would be better to ask the Hague Conference to create a multilateral, generally applicable convention. So the chances came to Asia as well. So, but still, the many things were within European hands. So the 1999 preliminary draft and the 2001 interim text shows a lot of European influences. And we can, I think, just as a superficial idea from outside, personally, I think I can understand that, because in that period, Europe was really integrating to a very high level, and it's difficult for one body to discuss the European regulation on the one hand and the Hague Convention on the other, dealing with largely the same subject, but differentiating the stage of development. This is quite difficult, but somehow that worked. So, but before that, from 2002 to 2005, in the second phase, the Hague Conference dealt with something that can be parallel to the 1958 New York Convention. New York Convention dealing with arbitration, beginning from arbitration agreement. So 2005 Choice of Court Convention begins with choice of court agreement and then deals with circulation, what other courts should do. So 2005 Convention success also was a stimulus for continuing the work. So in 1910, the work was reactivated, and now what we have is 2019 Judgments Convention. Judgments Convention meaning recognition and enforcement of Judgments Convention. So it's only deals with recognition and enforcement of judgments and also judicial settlements. So this is a modest approach. I think European Union, Switzerland, other European nations did a very good effort, I think, to accommodate others, because European regulation is going much more toward much closer integration. But on the other hand, for broader context, this is our common beginning point or common baseline, we could say. So, and we are now in the fourth period, we could say. Professor Takeshita is our respected chair, so the next session we'll talk about that. And what are the common framework? Common framework, just a convenient term for me to talk about framework of the two conventions, but resembling the New York Convention framework. But we should also understand that the two conventions didn't just come up, didn't just emerge out of nowhere or only an extension of European developments. Rather, some kind of common emerging standard was there, I think. So that was the background for creating New York Convention when the world was quite divided. And still that idea works, I think. So the basic question for private international law is which country should deal with it? So for judgments and jurisdiction, which courts have jurisdiction in the eyes of themselves or in the eyes of the recognizing courts? And judgment recognition is maybe a relatively less difficult topic than direct jurisdiction. So the framework is already there. Jurisdiction, indirect jurisdiction, or jurisdictional review, plus some defenses. Defenses largely growing out of public policy defense. So this is how New York Convention was created. And also in the continuum, we have two choice of court convention and judgment convention. And what are the 2005 choice of court convention? The basic structure is, as I just mentioned, quite similar to New York Convention with a little bit of further articulation. So to make it more parallel or to make this convention more easily accommodated in practice, perhaps that could be the reason. But this convention focuses on exclusive choice of court agreement and what results from that agreement. So we choose only that country's courts or that country's specific court. And it functionally it is similar to choosing to arbitrate under certain rules, certain arbitrators. So it may have been, this parallel aspect may have made it easier to negotiate. And also this ease in the practice of negotiation may have contributed to retain the earlier drafts. Although the convention takes a more cautious, conservative approach. So the traditional writing requirement is there, and also the convention kindly says in Article 5, it says chosen court is obligated to exercise jurisdiction. In Article 6, the convention says talks about what derogated courts, unchosen courts should do. In Article 9, what are the requirements, the threshold for recognition enforcement of the judgments given by the chosen forum. So it's quite logical. It's a double convention, but not burdensome because already we have New York Convention there. Perhaps it was also logical for the convention to talk about what the chosen court should do, while the New York Convention was not in a position to say what the arbitrator should do. So there's a little bit of difference in context, but largely similar. But we should also note that there are interesting developments, further developments. One could be the rules, some detailed rules for recognition enforcement. First, not just the 2005 convention, but the two conventions minimize the refusal of recognition or enforcement if the excluded issue, because the two conventions limit the material scope. If the excluded issue arises as a preliminary question, then refusal of recognition and enforcement should be minimal. That is also in line with the earlier developments and predecessor legislations, and also as a useful compromise acceptable to many people, many countries. The two conventions allow categorical refusal of non-compensatory damages, punitive damages, whatever multiple damages serving as moderated punitive damages. These are, you may exclude them from this enforcement regime. Well, of course, you may circulate them under your national rules, but you don't have to. All your drafts were a little more nuanced, but two conventions just offer simpler solution. And judicial settlements are also covered. And also, procedure of recognition and enforcement is left to national rules. So it's easy to join. Interestingly, these additions were already there in the choice. Most of them were already there in the Choice of Court Convention, and then also adopted again for the Judgments Convention. And some more articulation may may appeal to more interest. The New York Convention, as many of you will know, it uses the term some incapacity. Does it only talk about capacity issue, or does it talk about power of representation also? In the Choice of Court Convention, the relevant defense says incapacity, lack the capacity. So I think there's a little more nuance toward defining the term capacity in its proper sense. Another one notable improvement I could say, is that when the chosen court upholds the validity of the choice of court agreement, then the recognizing court should accept that part of the finding. So that is also a little more advancement from the New York Convention. And what are the 2019 convention? It is a single convention, only deals with jurisdiction, not jurisdiction, but recognition and enforcement of judgments. And also not an exclusive, it doesn't have an exclusive list of jurisdictional filters. Jurisdictional filter is there. Therefore, to guarantee that indirect jurisdiction will be upheld. So, and not just about jurisdictional filters, other rules for recognition and enforcement may be lowered in national rules. So it's okay to circulate foreign judgments more easily under national rules. So the famous epithet, I'm sorry, but I don't know who are really the author, but floor, not the ceiling, is a very concise, telling epithet. So we built the groundwork, you can build further on. And let me just skip the jurisdictional filters bit because it will be discussed in further detail. But let me also mention there are yes, there were some additions. List pendants number 4 is also interesting because when litigation is pending and foreign court has issued a judgment on over the same case, list pendants can be a refusal ground. Well, the standard is a little abstract. The recognizing court should have ceased first, and then there should be close connection with the recognizing court. So what do they mean? Especially what close connection mean? Yes, it's vague, abstract, so I'm conservative about, I'm cautious about joining the convention, but thinking differently, even states with less history of judgments convention type bilateral or multilateral arrangement can participate from the initial stage, joint efforts to clarify what this means. And security costs is another addition in the Judgments Convention. And it is prohibited, but then if you lose in the recognition enforcement, in seeking recognition enforcement, you have to compensate, and the compensation order will circulate automatically. This itself is a compromise, useful compromise, but still there's further pragmatism there, so you may reserve this mechanism. So this shows another sign of flexibility of the Judgments Conventions. But let me also mention that there are many exclusions, in fact. Some exclusions were deleted in the Judgments Convention. Some additions were added in Judgments Convention. You can easily understand that because when Choice of Court Agreement Convention, for example, excludes consumer and employment contracts. But for Judgments Convention, there may be diverse matters, diverse types of cases. So negotiating parties came up with the idea of adding exclusions. They come from a realistic approach. So personally, I think it is complicated, but this is the world we have to live with. Contracting states may also make declarations, and particularly important one is number 3, Article 21 in the earlier one, 1918, in the Judgments Convention, declaration with respect excluding specific matters of important interest to the state. So this can be another bumper for each contracting state. And also there's a refusal mechanism. I refuse to have treaty relations with that country. But as far as I understand, this is there as a guarantee. This is not really there to be used frequently. So it's kind of an indirect influence is the key to this mechanism, as far as I personally understand. And there are other mitigating factors. The conventions, 2 conventions do not cover direct jurisdiction, other than choice of court. And lis pendens is also left to another phase. And limiting the jurisdiction, that idea is not really there. So the 2 conventions are, you can say one directional, but they don't cover many jurisdictional grounds. So, but if the judgment is based on this really very common shared jurisdictional grounds, why don't we circulate it more effectively? That's the idea. So if each contracting state is a little hesitant, then I think the better way is to think about in what area state interests are materially involved, and avoid that area and join the convention, join the joint efforts, and come together in the way to achieve further objective. And what can be the further objective? Perhaps, by the way, let me just mention that in Asia, some states struggle to have their own specialized fora, international criminal courts. Yes, if you do that, I think it will be very useful to have choice of court convention, partly because choice of court convention also deals with international choice, but also inter-regional, the intra-state choice of court when it's accompanied, when the parties choose one country and one specific court in that country, that the whole package is regulated by the choice of court convention. So nice support for the international commercial court boom, I could say. And joining the 2 conventions can be a very good way to overcome the division of Asia, the lower level of integration within Asia. Perhaps the best way, at least in theory, because the two conventions follow the universalist approach. And and in Asia, perhaps maybe in other regions, but particularly in Asia, somehow anti-suit injunction is flourishing somehow. So, but continental European countries are not wholly immune because when we put priority on local judgments in recognition phase or in list pendants context, at least internal regulation is concerned, it will work in a similar way. So it just reminded me of some 19th century episode about penalizing cooperation with foreign authorities or foreigners. I think it is time to at least gradually depart from it, but we cannot be too ambitious. We have to have mutual trust built on existing law and further development. The two conventions are on their way to that high level of mutual trust that would someday justify finding anti-suit injunction or categorical priority given to local judgments. Someday they could be found not very useful. But the two conventions are not enough, but I think it is the common starting point, and it should be the common starting point for Asia as well. I think I just exceeded the 20 minutes limit, so let me just finish.
Can you finish? Just in 5 minutes. Yes, because you didn't say about the benefits of the two conventions. So
I see. Thank you. So what are the benefits? When two conventions apply in their material scope, they have direct benefits. But I think we can build on recognizing and enforcing judgments with that selected areas. Some parallel could be drawn to the United States approach of recognizing and enforcing money judgments first, and then slowly developing a reciprocity-based recognition and enforcement of other judgments. What we are doing in The Hague is differentiate by one matter after another, but I think this kind of incremental development, constructive development can also happen. And we are codifying the common core, existing or almost existing common core, and give more clarity, more certainty. And Asia should not be too cautious about joining the recognition enforcement network. And also, it can be a building block for fostering common development of some concepts may be novel. For example, consent jurisdiction is still novel for civil law world, but it should be express consent, and then it is inside the Judgments Convention. So rather than trying to judge consent jurisdiction with our own standard, civil law jurisdictions will begin looking at consent jurisdiction based on consent jurisdiction provision. So learning new concepts. And also abstract concepts. So feeling the concrete contents of the abstract concepts are for everyone. And also, lastly, I would like to mention the synergy of joining the two conventions, also together with the New York Convention. As far as I understand, if you agree on a choice of court, exclusive choice of court agreement, and then it is found invalid, but still it is the Judgments Convention can apply because there is no valid choice of court agreement. This can be the situation for Judgments Convention. So, somehow many Asian states may have some worries about choice of court convention, partly because our court is not very likely to be chosen. But the joint effect of the two conventions means that if the parties choose a court that appears in the jurisdictional filter of the Judgments Convention, then even if the choice of court agreement is found invalid in the worst case, still there's a possibility to use the Judgments Convention. So, and other rules are very similar in two conventions. And interestingly, Professor Bourne's critique about the two conventions came up after the Judgments Convention was about to come into effect or came into effect. So why? Why not after 2005, but why the critique came along in after 2019 convention? I think it may be too much imagination, but perhaps Professor Bourne noted the synergy effect of the two conventions. Well, the evaluation may vary, but the synergy must be there. The joint cooperative effect should be there. And another issue is, why do we have to adopt a convention whose rules are already known to me? Oh, they are too familiar, nothing new. But nothing new may be a good idea because, well, parties rely on our own jurisdiction rules, recognition and enforcement standards. And if there's a guarantee that many other courts follow the same standard, well, isn't it a good thing? Rely on the law of the issuing court, and then the same rule will apply elsewhere. And vice versa. You can also choose to sue abroad, come back to your own country. So I think the modest nature, the cautiously prepared contents of the two conventions are more benefits rather than disadvantages. Thank you.
Thank you for your insightful presentation. Give him the round of applause to him. Okay. For your information, it should be noted that the anti-suit injunction was issued recently by the Chinese court in terms of the standard essential patents. So now we will move on to the panel discussions. First, panelists and the second panelist, actually those were especially we are dealing with the transnational issues. However, those two persons are the transsessional. They are the panelists for this session and the next session. So the first transsessional panelist is the Professor Marcelo Di Nardi. He is a professor of the University of Valle do Rio dos Sinos. Is pronounced correct? And also he is the judge as the Court of Appeals in the 4th region in Brazil. He came the long way to come here. At least he need to give 15 minutes. Otherwise, it doesn't make sense because it's a 12 hours time difference. So also he's I think that nationality is very important. It's a very important connecting factors in the field of private international law. He's a Brazilian. Also, he's Italian. So we need to listen to him. Very broad and sense. Okay, the floor is yours.
Thank you for the generosity, and thank you for the organizers for the opportunity to bring me here. I'm really enjoying this trip to know Seoul and all the friends that I see here in the podium and in this panel and over the audience here. I'll thank Professor Young-Hyuk because he opened the doors for the convention, making my task much easier. I would like to address you the topic of consumer protection, both in choice of court convention and the judgments convention. Professor Young-Hyuk mentioned the choice of court convention is a double convention in the sense that it establishes direct rules for jurisdiction, one direct rule for jurisdiction, that is the existence of an exclusive choice of court in a certain legal situation. And the Judgment Convention is a single convention in the sense that it only provides for the obligation for the states to recognize and enforce under certain circumstances. This is crucial to what I would say from now. So consumer protection, how it is established in choice of court. The essence of consumer protection choice of court is the exclusion of the topic from the scope of the convention. The convention provides for establishing the jurisdiction and the obligation to recognize and enforce a judgment coming from that jurisdiction based upon the existence of a choice of court, exclusive choice of court agreement. It is important to understand that choice of court convention do not provide for a contractual legal situation where we have exclusive choice of court agreement. So we can have a situation where it is not a proper contractual regulation. But if you look to the exclusions of scope, it directs to that conclusion. This is an important thing. So you will find very little situations that are not contractual that would fall within the scope of COCA or not excluded. So how the exclusion for consumers is established? It states a definition of consumer, and I'll read. This convention shall not apply to exclusive choice of court agreements to which a natural person acting primarily for personal, family, or household purpose, a consumer, is a party. So this is the exclusion. One might think that in general, most cases where we would make fall into the definition of this definition would be covered, but I dare to try to find some situations that most jurisdictions would think they are actually consumer situations, and then I'll direct to my Brazilian experience on this. One exception, clearly, that is a gift to a colleague of work. You go to a small store, buy a simple gift, whatever, to a colleague of work. This is not personal, nor family, nor household. It is your boss in a work, that it's a temporary work. It's not something that you could fall directly or precisely to the definition. If that particular gift harms the consumer, we can have a situation where choice of court may apply if after the situation, it is a tort situation, after that situation it would be possible to enter into an exclusive choice of court agreement before dispute. On the other hand, one might not pay for the goods bought, and then the provider can act against the consumer and try to recover. So if this particular situation doesn't fall into the, is found not to fall into the definition, choice of court may be applied and then generate a situation where consumers are supposed to be the weaker party. They should be thus protected. This is the general idea. In this situation that I figured, of course, it's a marginal situation. The provider can have an advantage based on the convenience of the forum chosen. Other situations that I figured that might fall out of the definition, the misconduct of the consumer that damages the provider, depending on the nature of the service or the product, the consumer may act in the sense that it harms the provider. One that comes to my mind right now is the use of social media to address bad evaluations or bad comments against the provider. This could be something that could be done there. There is a classic German example of the what became known as the bystander. We had a terrible case in Brazil where there is a shopping mall, and people used to cross the shopping mall just for strolling, looking for the shops, or just crossing from one street to the other. And eventually, there was a serious gas explosion harming a lot of people that was just crossing through that shopping mall. Are they consumers or are they not? In that situation, it may apply the choice of court. Let's remember, this case involved a lot of people. 200 people were harmed, and a few of them died in that situation. And we can find some possibilities of connecting to choice of court. And an accident within a store also could be a possibility. But choice of court has an express exclusion connecting to torts or delicts. That is in Article 2.2k. That says it is excluded from the scope of the convention situations of tort or delict claims for damage to tangible property that do not arise from a contractual relationship. Okay. So it is narrowing the possibilities of consumer being a situation within COCA. So in general, consumer would be protected in the sense that in very few cases, very marginal cases, there will be an exclusive choice of court agreement that would point jurisdiction to one jurisdiction that is not convenient for the consumer. In general, there will be no harm from this situation. If it comes to light, then in very marginal situations, again, the three international obligations established by the choice of court agreement would be to assume jurisdiction if the contracting state is the chosen forum, to reject jurisdiction if the contracting state is not the forum, or to recognize and enforce the judgment coming from the chosen forum. If that particular situation comes against the consumer, and please take note of this last phrase, if the judgment comes against the consumer, then if choice of court applies, there will be little possibility of refusing under the general, specific, exclusive, not general, the exclusive rejection possibilities, but there is always a recourse to the public order or public policy protection that could refrain that situation to protect in the end, the consumer, and that would be probably the Brazilian solution if Brazil was a part of choice of court. Let's jump to judgments again. Let me recall that judgments is a single convention. The only international obligation established is to recognize and enforce, and it is a bit different, the protection down there. Consumers are not expressly excluded from the scope of the convention, but there is a special provision down there that limits the basis for jurisdiction that applies to the situation where the judgment is rendered against the consumer. So there are two ways to protect the consumer in judgments convention. The first one is put consumer when he is he has the benefit of the judgment. If the judgment is rendered in favor of the consumer, he can use all the full possibilities of the judgments convention, facilitating the circulation of the judgment that was rendered in favor of him. If the judgment is rendered against the consumer, then it enables Article 5.2 of the convention that excludes some of the bases that were listed, particularly in Article 5 and Article 6 of the convention, that are the key for the operation of the convention. So, in essence, what Article 5.2 is define consumer in a similar way of that it was defined in the Choice of Court Convention. And I'll read Article 5.2. It is embedded in Article 5.2. A natural person acting primarily for personal, family, or household purposes, a consumer, in matters relating to a consumer contract. Okay? We have a difference here, the reference to matters relating to a consumer contract. So tort is possible. Remember the exceptions that I mentioned to you. A gift to a co-worker, the misconduct of the consumer that damages the provider, the bystander situation, or the accident within a store that would be covered under that definition. Probably not. Meaning that those situations where most jurisdictions would find consumer situation, would not benefit on the protection that we have on these particular situations defined here. So those situations, if a judgment is rendered against a consumer, would fall on the general rules. And what are the rules excluded to protect consumers? In essence, the rules that establishes choice of court. The written choice of court that would be correspondent to choice of court convention, the tacit submission, and similar situations that would enable. The Article 5.2 then, to those situations depicted in the model of consumer, excludes some basis of jurisdiction that would enable the recognition and enforcement if the judgment was rendered against the consumer. This is how it is protected. So this is how I see, how I read the convention. And I would note that there is two ways of seeing it. Again, I will repeat this. The benefits of the convention could apply fully in favor of the consumer, but if the judgment is against the consumer, then it can benefit of some protection, some restriction of the facilities of recognition and enforcement, in the sense that would push the provider to follow the consumer habitual residence, which is in general what we have if we are dealing with natural persons rather than companies. So this is what we have. That was in the negotiations that I had the honor and the privilege of participate in the name of the Brazilian delegation. And this particular topic I really discussed a lot with my colleagues down there in the negotiations table. And that was found to be, in general, by the participants of the diplomatic session that resulted in the convention, to be sufficient protection. I remember discussing this topic with my thesis supervisor, Professor Claudia Lima Marques, down there in Brazil. She's a renowned specialist in consumer protection, and she was really against it. No, this won't work, just exclude consumer. I said, no, professor, we need to have the part in favor of the consumer. The benefits should be allowed in favor of the consumer, and I managed to convince her, give or take. So this is it. So I'm approaching the end. Let me recall also one of the phrases that Professor Juniak used. The convention is supposed to be a floor, a minimum for recognition and enforcement. This is an important idea for the convention. And we have Article 15 that provides for national law being more open to recognition and enforcement. But let's remember the idea in Article 5.2. Article 5.2 is a restriction to the floor, meaning that it is more strict when the judgment is rendered against the consumer. This is the problem that we have. Can, in this situation, national law overlap this extra restriction? Meaning that if the consumer, in the consumer situation, the judgment is rendered against the consumer, and it was rendered in a court that was named in a written choice of court agreement, can a state also recognize and enforce such kind of judgment? The easy answer, from a logical point of view, with a strict reading of what is in the text, the answer is yes. So we are weakening the consumer protection with this understanding. And this is something that we need to have case law to see how this problem would be solved, if it needs to be solved. So probably in those jurisdictions, the consumer protection would be lower than the other standards in other situations, in other jurisdictions. And this is the reality that we live. We have different levels of consumer protection in different countries. So there is a possibility, at least a legal, logical possibility, that this would happen. So case law would be needed, and we shall rely on uniform interpretation, Article 20 of Judgments Convention, for the purposes of having then a strong case law on this particular matter. So all the situations, and this particular risky situations, can enable in some countries like Brazil particularly, and I would name also Argentina, who recently modified its rules for recognition and enforcement connected to consumer, I would say some 8 to 10 years ago, very restrictively, very protective of consumers in Argentina. And both of these countries may use the general public policy protection, public order protection clause to block, to refuse recognition enforcement of a judgment against a consumer in those situations. So those two countries probably a provider won't be successful. Finally, all these risks can be addressed through declarations. Professor Jinyoka has mentioned the possibility of declarations. They are really wide, but they are commanded by the convention to be as strict as possible. So this is a possibility. If a state needs to have extra protection, then it can declare restriction extra to protect consumers. Thank you again for giving me the floor, for having the opportunity to address this, and I'm available for your questions when it is proper to have. Thank you very much.
Please give a big hands for him. So he is trying to show the several scenarios related to the consumer protection as far as two conventions are concerned. Now, as I said, we have another transsectional panelist, Professor Kyung-min Yeo. He's a professor. He's a Yong-Pong Hao Chair of Professor of Law at the Singapore Management University. He used to serve as a senior research fellow at the University of Oxford. So I think Singapore is one of the key countries which adopted 2005 choice of court convention. So we have a lot to listen to him about it. So the floor is yours.
Thank you very much. First, I'd like to thank the organizers for inviting me to speak at this conference and affording me the opportunity to address this distinguished audience. Now, Singapore is the only contracting state to either of these conventions on the Asia side of the Pacific. So I thought I'd share with you our experience with the 2005 Choice of Court Convention. The background to this, I think you need to understand a little bit about Singapore. Singapore is a tiny country with a population of about 5.5 million, which is just over half of the population of the city of Seoul, I believe, right? It's a very small country, no natural resources, a highly globalized economy that relies very heavily on the services industry. And that, of course, includes the legal services industry. And as a country, we're trying to build up a hub for dispute resolution, either a regional or a global hub. And as a result of this, it is very important that our laws are aligned with international legal standards as far as possible. So from this perspective, the work of the HCCH is really, really important to a country like Singapore, okay? And Singapore signed on to the Choice of Court Convention in 2015. It took effect from 1st of October 2016 as part of the strategy of Singapore to build up this hub for dispute resolution, a one-stop dispute resolution, not just for litigation, but also for arbitration and mediation. And so Singapore is also party to the New York Convention on Arbitration and, of course, the Singapore Convention on Mediation. But it's not just business-driven, of course, because I think the fact is that when people seek dispute resolution, they don't always want litigation as the only option. For various reasons, they may prefer mediation or arbitration. And in fact, today, the multi-tiered dispute resolution clause is becoming more and more common, right? So we thought it's important to provide the one-stop forum for dispute resolution. Yeah, anyway, that's sort of the history behind the Singapore becoming a contracting state to the Choice of Court Convention. The 2019 Judgments Convention, we are not a contracting state yet. As far as I know, the matter is still under consideration by the relevant ministry in Singapore. Now, since the adoption of the convention in 2016, we've seen a few cases coming out from Singapore. Nothing really dramatic, which is in a sense a good sign because the implementation has been really smooth, right? Because we really face no real problems in the implementation of the convention. Maybe in part for us, the convention did not create any fundamental change in the way we approach choice of court agreements. The common law in Singapore places great significance on party autonomy, and the common law is very strong in giving effect to choice of court agreements. So the first case that came out from Singapore was a case called Gasson and 6cap Financials, which was the case on the enforcement of foreign judgments under the convention. And this was a case of an enforcement of an English summary judgment in Singapore. Again, nothing dramatic about the case, except that it's the first case that we know that talks about enforcement of foreign judgments under the convention in Singapore and possibly in the world, right? And the another case that came out quite recently had considered the question of whether the choice of court convention applied to asymmetric choice of court agreements. And asymmetric choice of court agreements is one where the choice is not symmetrical, right? It's not a case where both parties agree exclusively to a particular forum, but where one of the parties have made such an agreement, but the other party has reserved the right to sue, usually in multiple jurisdictions. And there's been a question as to whether this sort of choice of court agreement falls within the convention. The explanatory statement, I think, makes it clear that it doesn't, but there have been some cases from the UK that have suggested that it may. Right, but one Singapore court has taken the position, relying very heavily on the explanatory report, that this is not caught within the convention, right? The third case that we've seen is a slightly bigger case. This is the 6DM and AE Brands case. It's a fairly straightforward case of dismissal of proceedings under Article 6 of the Convention. Singapore was not the chosen court. This case involved multiple contracts, where the relevant agreements contained an exclusive choice of English court clause, which were found to fall within the scope of the convention. And none of the exceptions for taking jurisdiction could be found on the facts, and so the court said, well, we dismiss the case. Okay, and one common factor in all these cases was that the court made very extensive references to the explanatory report to the convention in all three cases. And I think that shows the importance of the explanatory report in trying to understand the text of the convention. So one reason why these cases are not really dramatic is that it really made no change to Singapore law. If we had applied this common law, we would have reached the same conclusion anyway, right? But I think this goes back to the point that Professor Zhang was making just now, that it may not make a dramatic change to your own jurisdiction, but at least when parties choose the forum, they know that contracting states, not just in one country, but other countries will give the same effect to the convention, so it gives greater certainty to cross-border transactions. But what does arise from this case of 6DM and AE brands are a couple of latent issues. Latent because the matter was not argued. Singapore has an adversarial system, which means that if the lawyers don't raise the arguments, the court does not address those arguments. So, and there were at least two latent issues in this case. And one was the question of waiver, because the court considered whether the defendants had waived its objection to the jurisdiction of the Singapore court as the non-chosen court by its conduct in by its conduct that could be said to have amount to acceptance of Singapore's jurisdiction to hear the case. And in considering this point, which the court ruled in a negative anyway, the court implicitly acceptable that it is possible for the parties by conduct to waive their rights under the convention. And this is not explicit in the convention whether this can be done or cannot be done. So it raises one question that probably calls for consideration in the future for further case law, whether or not the convention allows for waiver by the parties, and if so, then what is the law that governs it? Is it a convention issue? If it's a convention issue, then what law governs it? Would it be the law that will be applied by the chosen court? That's one possibility. If it's not a convention issue, would it be an issue of procedure governed by the national law of the forum faced with the issue? Or is this a question of contract law, because it's about the enforcement of an agreement between the parties, possibly governed by the law governing the choice of court agreement? So this is one question that I think remains to be settled. The other latent issue that came out of that case is a problem arising out of the Brexit, right, when UK withdrew from the European Union. On 31st of January 2020, there were fireworks all over the UK because they celebrated the exit of UK from the European Union. Now, one of the clauses in this case, in one of the contracts here, was dated 1st of February 2020. It was after Brexit, right? And so the question here is whether the parties have chosen the court of a contracting state. Was the UK a contracting state on 1st of February 2020? This was during the transition period for UK withdrawal from the EU. At that point in time, it was no longer part of EU, but we know UK independently joined the convention with effect from 1st of January 2021. But you cannot rely on that independent contracting state argument for this clause because this was 1st February 2020. Okay? But we also know that there was a withdrawal agreement made between the EU and the UK, where the EU agreed to treat the UK as part of the EU for the purpose of applying treaties. And this withdrawal agreement is effective within the EU. So we see from one very recent Belgium case that the UK remained a contracting state during the withdrawal period, as far as Belgium was concerned, because Belgium is part of EU, right? Belgium is part of this arrangement in the EU, where UK is, although no longer part of EU, will be treated as part of the EU for the purpose of applying treaties. But the problem is, of course, this withdrawal agreement has nothing to do with Singapore. Singapore is not party to this withdrawal agreement, and neither would any of the other contracting states outside the EU. And so the question then would be whether UK can be treated as a contracting state for the period between 1st of February 2020 and 1st of January 2021. Another consideration is the declaration by the EU, by the UK, right? Because the UK made a declaration that the convention applies in the UK continuously from 1st October 2015 onwards, right? And so UK regarded itself as a contracting state in a unilateral declaration, right? So, but again, does that make it a contracting state? Can you, by declaration, make yourself a contracting state? I'm not sure what the answer is. This is something that may call for further analysis, both from the perspective of private international law and public international law. Right? So this is one of the questions that was latent in the case, not addressed. But I think these are not implementation problems. These are problems of interpretation of a convention. You will always have these kinds of problems whenever you sign on to a convention. As I've said, the implementation of the convention in Singapore has been extremely smooth as far as I can see, no problems with it, okay? And the other point I want to make, and I don't have to spend much time on this, I don't really want to go through the my next few slides. I just want to go through them very, very quickly because I think one of the other benefits of signing on to this convention has been the soft law effect of the convention. Although the convention itself may not be actually applicable in a particular case, it stands for a certain position taken by the international community on certain issues, and it can be used in the development of our own national law, private international law. So we had a few cases where the convention was considered, right, in looking at how the common law should develop. And I don't really want to, I think there's no need to go into the details of this national law, right? But just want to make the point that they're also important as soft law influence. Right? And with that, I think I can conclude my session. Thank you very much.
Thank you for your insightful discussions. Now we'll have the third panelist, Professor Pietro Francina. He is the full professor of the private international law at the Catholic University of the Sacred Heart in Milano, Italy. Normally, I pronounce like Milano. It's much preferable to me. Anyway, he's serving as a member of the delegation of the European Union to the experts group on carbon markets of the Hague Conference on Private International Law since this year. Also, the Professor Zhang and I are the members of the European Association of Private International Law. We finally met the Deputy Secretary General of the our association. So it's him. So now the floor is yours.
Many thanks. I wish to express my gratitude to the co-hosts of this conference for having me, and allow me also to express my gratitude to all those involved in the organization for all they have been doing for taking care of us, the speakers, and everything. So I will be spending a few words on the jurisdictional filters that are provided in the Hague Judgments Convention. I will benefit from the excellent presentation that has been provided by Junhyuk Chang, so I will be able to be very quick on some general remarks, and I'm sure I understand the concern of the moderator that time is limited, so I will be as short as simple. It has already been said that the Hague Judgments Convention is a single or simple convention, meaning that it is only concerned with the recognition and enforcement of judgments, and it does not provide rules of direct jurisdiction, meaning, in other words, that states that join the Hague Judgments Convention are not required under the convention to revise their rules of direct jurisdiction. They can keep using their own rules of jurisdiction, whether or not these are consistent with the jurisdictional filters of the Hague Judgments Convention. The Hague Judgments Convention provides that for a judgment to be eligible for recognition under the convention, it must originate in a contracting state with which the dispute had a connection, the kind of connection or one of the kinds of connections that are established for this purpose by the Hague Convention itself. There are several such requirements of indirect jurisdiction that are provided in the Hague Judgments Convention, and in order for a judgment to enjoy recognition under the convention, it is sufficient that the judgment fulfills one such requirement. Any filter will do. It has already been said, but it is important to reiterate that the Hague Judgments Convention, apart from Article 6 on immovables, does not intend to preclude the possibility for the states, for the contracting states, of relying on their own domestic rules on the recognition and enforcement of judgments, even in cases that are within the scope of the Hague Judgments Convention. In other words, if a judgment does not meet the requirements for recognition that are provided in the convention, it can still be recognized if the domestic rules of the requested state so provide. Let me also stress the fact that indirect jurisdiction and direct jurisdiction are not only functionally different. Direct jurisdiction is important to assess for a court, for the court sees of the matter whether it has the power to rule on the case. Indirect jurisdiction instead is important to determine whether a judgment is fit for recognition. So the purpose is different, and it also means, by implication, that when it comes to determining whether indirect jurisdiction requirements are met, it is unimportant what kind of jurisdictional rules have been used in the first place in the country of origin. In other words, the assessment of the indirect jurisdiction for the purposes of recognition does not amount to a review of the direct jurisdiction of the court of origin. Now, as I have said, there are several jurisdictional filters that are provided for in the Hague Judgments Convention, and in order to illustrate these jurisdictional filters, a possible approach consists in grouping the various jurisdictional filters into headings, and I suggest using 3 such headings. There are some jurisdictional filters that have to do with the idea that jurisdiction is a synonym of power. Jurisdiction is justified on the part of the courts of a state to the extent to which the dispute or the litigants is somehow within the reach of the sovereign prerogative of the state whose courts are seized. And one example of a jurisdictional filter that reflects this idea of jurisdiction being associated with power is the jurisdictional filter in Article 5.1a of the Convention, whereby a judgment is eligible for recognition if the person against whom recognition and enforcement is sought was habitually resident in the state of origin, meaning was within the scope of the territorial powers of the state of origin. Other jurisdictional filters rather have to do with proximity as a ground, as a justification for the exercise of adjudicatory jurisdiction. These are subject matter specific heads of indirect jurisdiction, and the idea behind them is that when a objective connection exists between the dispute and the forum, then it is appropriate for the forum to exercise jurisdiction, meaning that it is also appropriate for another state to give effect to a judgment based on such a heading. Article 5.1j of the Hague Judgments Convention provides an illustration of this logic of proximity. It refers to judgments which ruled on a non-contractual obligation, and it provides that such a judgment is eligible for recognition when the act or omission directly causing the harm occurred in the state of origin. Finally, there is a group of rules of indirect jurisdiction that rather rely on the idea of consent. If the parties or the party against whom recognition is sought consented to the court of origin having jurisdiction, that is enough a reason for the requested state to give effect to that judgment. Now, I have selected a few filters, and I will rapidly go through them just by way of illustration. Since the time is limited, I will skip a few details. I have already mentioned the filter in Article 5.1a, according to which a judgment is eligible for recognition if the person against whom recognition and enforcement are sought was habitually resident in the state of origin. There is an interesting and highly useful, in fact, clarification in Article 3.2 of the Convention as to what should be understood by habitual residence, in particular when reference is made to a person other than a natural person, so a company or an entity of some kind. Various locations of various projections are being used as a synonym of habitual residence, including the statutory seat of the person in question, or the state whose law is the law under which the entity was incorporated or formed, but also the central administration is a synonym of habitual residence, and the principal place of business is also a synonym of residence. Now, these four locations are alternative, meaning that there is no such thing as a hierarchy between these projections. So any place where the habitual residence, as understood in this provision, is located will be a good venue for litigation for the purposes of recognition under the Convention. Branches also are an interesting topic. There is a specific head of indirect jurisdiction in Article 5.1d, according to which a judgment benefits from recognition and enforcement under the Convention if it relates to a dispute involving a branch and it was rendered in the state in which the branch is located, provided, however, that the dispute relates to the activities of the branch. Now, it is explained in the explanatory report of the Convention that reference is made here to articulations of a single entity, so not different entities. Branches are not separate entities from the company or entity concerned. They are just locations, articulations, geographical articulations of a single entity without legal personality. For a branch to exist, there must be a stable physical presence of the defendant in the state of origin. There must be some activity that is carried out in the branch and through the branch, and as I said, the dispute must relate to the activity of the branch. If it is a contract, for example, the subject matter of litigation, it must be established that the contract was either negotiated, concluded, or performed with the intervention of the branch. A few words on the particularly elaborate and interesting provision on contracts. According to Article 5.1g, the jurisdictional filter for contractual obligation, on top of the other possibly pertinent filters that might apply to contract generally, habitual residence and so on, is that the judgment related to contractual obligations enjoys recognition and enforcement under the Convention if it was given by a court of the state in which performance of the contractual obligation in question took place or should have taken place. The question then arises of how to determine the location of performance, how to determine in which state the obligation in question has been performed or should have been performed. If an agreement was entered into between the parties through a clause in the contract in question determining the place of performance of the obligation in question, then no problem. If no agreement was concluded between the parties, then Article 5.1g provides that reference should be made to the objectively applicable rules of the law governing the contract, which entails another question: how to determine the law governing the contract. There is no indication, there is no express indication in the text of the Convention as to how the law governing the contract should be determined for the purposes of the concretization, the materialization of this jurisdictional requirement, but it's clear from the logic of the Convention as a whole, and it is confirmed in the explanatory report, that since the question arises in the requested state for the purposes of determining whether the judgment is eligible for recognition or not, the rules in force in the requested state, including the rules on conflicts of laws, will apply or at least be taken as a reference for the purposes of determining the law applicable, and on that basis the place of performance absent an agreement between the parties on the place of performance. Interestingly, the provision comes with a safeguard, and the existence of this safeguard is a testimony of the difficulties that obviously, I would say, arise in a negotiation which involves, as this involved, tens of delegations from different parts of the world and from different legal cultures. The question arose of what to do with situations in which the place of performance of the obligation in question, as determined in particular by the law governing the contract, is random, arbitrary, or features a too weak a connection with the economy, if you want, the substance of the contract. Well, in this case, the requested state is, under Article 5.1g of the Convention, permitted to refrain from giving effect to the Convention. There is here a compromise that has been reached, an interesting one, a problematic one, as all compromises, of course, but we will see how this will work out between two different views, two different ideas of how to determine the location of a contract for private international law purposes. Just a few words on choice of court. It has been said that the Choice of Court Agreement Convention of 2005 deals with exclusive agreements, meaning agreements that confer jurisdiction exclusively on one court or the courts of one state. Well, what about the other agreements? Then there is a gap to be filled, and this gap is filled by Article 5.1m of the Hague Judgments Convention, which provides for the recognition and enforcement of judgments rendered by the court chosen by the parties under a non-exclusive choice of court, including, as it has been said, an asymmetric choice of court agreement. There is a concern here for the smooth coordination between the two Hague conventions. My very quick final remarks. When reading the convention, one has the impression that more details could be useful, and one might complain about the fact that the degree of precision, the degree of elaboration of some provisions is not as high as one could hope for. In reality, this is simply how things work in a multilateral and challenging framework such as the Hague Conference on Private International Law, and there are excellent reasons to believe that the inevitable uncertainties that exist once a new text, an ambitious new text, is published will disappear in time. We already have an excellent explanatory report which is very helpful, and we will soon have some practice to provide guidance to courts and practitioners. But apart from these supposed and, in my view, inexistent weaknesses, let me say that the very fact that this list of jurisdictional filters has been put together by those involved in the drafting of this convention is of huge practical value. This is Article 5 in general of the convention, and the convention in general is a grammar of private international law, is a way of creating a basis, a springboard for future developments. It is crucially important to have this basis because future developments will be easier. And what is interesting, and that's really my final remark, is that the Hague Judgments Convention, it is at once an ambitious piece of uniform law, but it's also a gentle and humble piece of uniform law because it does not preclude further developments and on the contrary invites states, regionally as the case may be, or bilaterally, to build on the convention to bring unification efforts forward. Thanks a lot.
Yeah, please give big hands for him. So our last and final panelist is Professor Haewon Mok at the Korea University School of Law. She served as a visiting scholar at the Harvard University. Also, she used to be a judge and a lawyer at the Kim Jang and Lee. So I think Kim Jang and Lee must be famous in the field of private international law. Two of our panelists, the speakers and the panelists, is from the Kim Jang and Lee. And I think that she told me that she's not the doctor, that she is about to be a doctor for years to come. So floor is yours.
Good afternoon. It is truly honored to be among such distinguished experts and professionals today, including our moderator, speakers, and co-panelists. I'd also like to thank to HCCH, the Ministry of Justice, and Judicial Policy Research Institute, and the Korean Private International Law Association for organizing and hosting this meaningful session. I feel privileged to be part of this important discussion. Back in 2017, I had the opportunity to participate in a study group under the Supreme Court of Korea, where we discussed whether a decision or judgment concerning intellectual property should be included within the scope of the convention. Through this experience, I came to appreciate how much comparable legal analysis has been invested in resolving each issue addressed by the convention. I'd like to express my sincere gratitude to those who have contributed over the years to the drafting and finalization of the Judgment Convention. Although this session also covered the choice of court convention, I will focus on my remarks on the Judgment Convention. In order to promote broader participation among states, it's essential to devise institutional mechanism that can extract common elements from the diverse legal system and mitigate differences. This mechanism can play a key role in dispelling doubt, uncertainty, and procedural discomfort. More fundamentally, the convention must instill confidence that joining it will not disrupt the domestic legal system, but rather will integrate naturally with existing case law and judicial precedent. As a Korean legal scholar, I'd like to highlight the compatibility between the Korean legal framework and the convention. Like many jurisdictions, Korea set forth requirements for the recognition and enforcement of the foreign judgment under Article 217 of the Korean Civil Procedure Act. To the best of my knowledge, Korean courts have generally adopted a favorable stance towards such recognition and enforcement. According to the empirical study analyzing enforcement cases decided or finalized from 2000 to 2019, only 34 out of 151 major cases were dismissed in whole or in part. While this 22% dismissal rate does not necessarily suggest a high enforcement rate, most dismissals were based on procedural grounds such as defects in the form of judgment or improper service of documents. The structure and elements of Article 7 of the Judgment Convention do not differ from those of Article 217 of the Korean Act. However, I'd like to highlight three particular aspects: as the service and notice requirements under Article 7(1)(a), conflict of judgments under subparagraph E and F, and reciprocity requirements found in Article 217 of Korean Act. Under Korean law, reciprocity is satisfied when the foreign country recognizes the validity of Korean judgment without examining their merits, either pursuant to the treaty or under its domestic law, on conditions that are the same as or more lenient than those under Korean law. The Supreme Court of Korea has further held that reciprocity may be satisfied even in the absence of precedent for recognition, provided that there is a reasonable expectation that a foreign court would recognize a comparable Korean judgment. Reciprocity does not require substantive equivalence in the legal conclusion of foreign judgment. Given that the convention establishes uniform ground for recognition and enforcement, and that, upon ratification, treaty obligation would prevail over domestic law, the convention may be said to serve the functional role of reciprocity. Thus, Korean accession would not require a major revision of its legal framework, even though reciprocity is not provided for in the convention. However, it is important to clarify that the convention's silence on the matter of reciprocity should not be construed as obligating Korea to unilaterally recognize judgment rendered by jurisdiction that refuse to recognize Korean judgment. Such clarification is necessary to avoid confusion within Korean's domestic legal context. Second, regarding the issue of conflicting judgment, Korean law addresses this issue in domestic cases through the doctrine of lis pendens and res judicata. However, it does not address conflicts between domestic and foreign judgments. Therefore, the convention provision distinguishing between conflict involving judgment from the requested state and those from third state are necessary and welcome. This provision reduces the risk of arbitrary denial of recognition and enhances the mutual trust and predictability in cross-border relations. Finally, I would like to address Article 7(1)(a). Korean law requires that the losing defendant must have received the complaint or equivalent documents in a timely manner sufficient to prepare a defense. If such service did not occur, the defendant must have otherwise participated in the proceedings. Notably, Article 217 excludes recognition of judgment based on service by public notice or similar method. The Korean Supreme Court has held that judgment based on public notice or presumably service, which service deemed complete regardless of actual receipt, do not satisfy the requirement for valid service. In contrast, judgment based on substituted service, such as delivered to a competent cohabitant or employee at the place of service, has been recognized. Under the convention, recognized may be refused where the defendant was not notified of the proceeding in a manner compatible with the fundamental principle of the requested state, or was not given sufficient time and means to prepare a defense. If a judgment rendered in a jurisdiction where service by public notice is deemed valid is submitted to enforcement in Korea, it will raise questions as to whether such service complies with Korean standard. Although Korean law allows public notice as a form of service under Article 174 and following provision, it excludes such service from the recognition of foreign judgments. This may be due to the fact that defendants who lose the domestic case by public notice service still benefit from certain procedure safeguards, such as extended appeal period. By contrast, foreign judgments are typically enforced through a single-stage process, offering defendants no meaningful opportunity to contest them. Recognizing judgment based on service method that the defendant likely never receive would therefore undermine the rationale behind the Korean's exclusion of public notice under Article 217. The convention, by refraining from prescribing any particular method of service, appears to have intentionally left room for each state to interpret fundamental principle and incompatible in its own legal and procedure context. Ultimately, determining what constitutes incompatibility with such principle will depend on the interest of the recognizing states. It is likely the future judicial decision from the convention's parties will further define the standard, including electric service, that potentially influencing Korea as well. In conclusion, Korea's joining to the judgment convention would formalizing its commitment to reciprocity, reduce the burden of foreign litigants navigating Korean procedure, and strengthen the legal certainty and predictability in cross-border enforcement. I sincerely hope that the convention will achieve its intended objective in the near future, just as its drafter envisioned. Thank you.
Thank you. Give it a big hand for her. I'm definitely new. I'm aware that we are behind the schedule. It's my fault. But my excuse is all of the speeches are excellent. So how can I stop them? So I'd like to open the Q&A sessions. So do you have any questions and comments? Yes. Please give. Yep.
Shall I start? I will try to be very brief.
Please identify yourself, your name and affiliation first. Yeah.
My name is Yoo Young-il, retired judge, currently a visiting law professor in Yonsei Law School. And let me continue. Okay. In this session, two treaties have been discussed, and I believe they will play a significant role in the area of international jurisdiction. However, I regret that neither is a binding treaty on comprehensive direct jurisdictional rules. I participated in the discussion of the Hague Judgment Project, which started in 1992, And I participated for 6 years as one of the Korean delegation members, starting from 1992 Special Commission to 2002 Diplomatic Conference. This grand scheme convention, with an objective of free circulation of judgment, aimed at a double convention, which provide direct jurisdiction and links these jurisdictional rules with mandatory recognition of the judgment. Yet, based on my experience as a judge, many countries, of course, including the Republic of Korea, are more interested in expanding its own jurisdiction, therefore are reluctant to relinquish exorbitant grounds of jurisdiction, making global consensus more challenging. My question is, do you believe a global agreement on direct jurisdiction will ever be achieved? If so, what is the primary obstacle? If such an agreement seems unlikely, should we understand the two conventions mentioned in this discussion, 2005 Choice of Court Agreement Convention and very recent one, 2019 Hague Judgment Convention, as having greater utility in this context? Thank you.
So the next questions, altogether we'll collect the questions and maybe the speakers and the panelists will respond to you all together.
Thank you, Professor.
Okay. Secretary?
I think I can answer the first question by saying, stay tuned, this will be responded in the next session. It's the topic of the next session, so we have done that. But I would just like to come back to the, first of all, thank you very much all for your very informative and interesting presentations. And I just want to come back to the very interesting and intriguing question raised by Professor Kyung-Min Yo regarding the date of entry into force of the Choice of Court Convention for the UK, because that was indeed a very hot topic. The UK had in fact reached out to the Permanent Bureau and had asked, how can we ensure that there is a continuing applicability of the convention in the UK following Brexit? And what we discussed was for them to make sure that they would exceed in the course of September 2020, meaning that the convention would then enter into force for the UK on the 1st of January 2021, according to the convention, 3 months later. And the only question that was then on the table, because it was undisputed that on the basis of the transition agreement with the EU, the convention would remain in force until the 31st of December 2020 as a result of the EU's approval, which of course also banned the UK back then. But the only question that was on the table was to know whether there was a magic second between the 31st of December 2020 and the 1st of January 2021 that would have interrupted the applicability of the convention. And the reason why this is so important from a practical point of view is that, of course, the convention only applies to choice of court agreements concluding after the entry into force of the convention in the state of the chosen court. So if there had been a new date of entry into force of the convention for the UK, all the previous choice of court agreements would have had to be renegotiated and reconcluded to ensure the applicability of the convention to chosen courts in the UK. And we discussed the matter also with the depository, the Ministry of Foreign Affairs in the Netherlands, and we said, well, it's actually quite simple. You just apply the same theory that you apply in the case of a succession of a state. Of course, UK and Brexit has nothing to do with succession, but the rule is the same. In the case of a succession, the date of entry into force is the original date of entry into force for the state, the original state, as it were, not the date following the re-accession or re-ratification of the new entity that claims succession of the previous state. So that's why the date of entry into force of the Choice of Court Convention for the UK is and remains the date in 2015 when it originally entered into force for the UK, without any magic interruption that would have taken place in the night between December and the 1st of January. And so this is the date on our website. This is the date on the website of the depository. The only ones who were against that result is, of course, the European Commission. But you may say that this is a political payback to say, no, you now have to wait until all these previous Choice of Court agreements are re-entered so that they continue to be applicable to the convention, which, in my view, is nonsense. But now, luckily, we also have a court decision from the Cour de Cassation of Belgium, the Cassation Court of Belgium, which confirmed that the date of entry into force is indeed 2015 and not 2021. So I think based on that approach, the depository, a first High Court ruling, as well as the position of the PB, for whatever it's worth, I feel quite comfortable to say that the date of entry into force in the UK is 2015.
Okay, I have to inform you that we are way behind the schedule. Do you have any questions and comments from the floor? Okay, now we're going to wrap up this session. Give the speakers and the panelists to give a warm round of applause. Thank you very much.
A sincere appreciation to all participants of Session 6 for a rich discussion on the Choice of Court Convention and the Judgment Convention. We'll take a break and resume with the next session at 4:15 p.m. Please enjoy your break and kindly make your way back to your seats 5 minutes earlier. The next session starts. Thank you. Distinguished guests, the final session will commence in a moment. Please make your way back to the conference hall and take your seats. May I also kindly ask the moderator, speaker, and the panelists of session 7 to take their places on the stage. Thank you for your kind cooperation. Ladies and gentlemen, we're soon starting session 7. So I would like to invite panelists of the session 7 to the stage. Thank you. Yes, now it's time to proceed to session 7, our final session for today. The topic of session 7 is prospects of the jurisdiction project. This session will offer valuable insights into the latest developments and the future direction of the HCCH's efforts to harmonize rules on jurisdiction and the recognition and enforcement of foreign judgments. It is a great honor to introduce our moderator, Dr. Christoph Bernasconi, Secretary General of the HCCH. Since taking office in 2013, Dr. Bernasconi has overseen the HCCH's development and has been at the forefront of numerous initiatives, including the jurisdiction project. As the head of the organization leading this work, he is undoubtedly the most fitting person to guide this session's discussion on its future prospects. Distinguished guests, please join me in greeting Ms. Dr. Bernasconi with a warm round of applause.
Thank you very much, Madam MC, and good afternoon to all of you. I feel very comfortable Thursday afternoon in Seoul. Private international law at the heart of our discussion, an excellent first panel, and we continue with excellent speakers and panelists here to conclude this afternoon. Slightly changing the nature of our discussions, because so far the nature of our discussions was de lege lata. We discussed existing HCCH conventions and their operation and implementation. And now we take a de lege ferenda approach to our discussions and discuss the law as it should be, or maybe in the future, and looking more precisely into the so-called jurisdiction project, hint, hint, in response to the question we had at the end of the last session. I'm delighted here again to be surrounded by dear friends and colleagues, Keisuke Takeshita, who of course is Professor, Dean of the Law Faculty in Hitsubashi University in Tokyo, and in particular, of course, he is the chair of the then experts group and now the working group on the so-called jurisdiction project. He is the man who never sleeps. He flies in straight from Tokyo and just keeps working in The Hague, and during the night then does his work at the university. But wonderful to have you here as a speaker, Kay. Thank you very much. Marcello Denardi has been introduced already, a professor and judge, and in particular my boss. So I will be very as a chair of CGAP, the highest organ of the organization, so I'll take good care of him. As I will, of course, also of Professor Chong-Min Yo from Singapore, who has been introduced already also, and he is, of course, also an active member of the delegation from Singapore on the jurisdiction project. Thank you very much for joining us also on this panel. And then Yoshito Inoue, I hope I got it right this time, professor also in Japan and a former colleague in the Hague, because he was posted at the Japanese embassy in The Hague, and Hae-min Lee, research judge at the Supreme Court in Korea here, and also with ties to The Hague in the past. Lovely, and without further ado, I think I will ask our distinguished speaker, Kei Takeshita, to set the stage, as it were, to explain what this so-called jurisdiction project is all about. Thank you very much, and an applause for him, please.
Distinguished guests, ladies and gentlemen, good afternoon to all. My name is Keisuke Takeshita. I am a professor of private international law at Hitotsubashi University in Japan, and I'm now engaging in the HCCH jurisdiction project as the chair of the working group. It is my great honor to be here as a speaker of such wonderful conference. I would like to express my sincere gratitude to the organizers of this conference, and I also thank all people who contributed to this conference. The title of my speech is HCCH Jurisdiction Project Updates. In my speech, I will explain the current draft provisions that the working group has produced as a result of its meetings. In 2023, at the Conference of Asian Pacific Week in Hong Kong, I also gave a speech on the project. But after that, many provisions were added and developed. I will relatively descriptively introduce to you all those provisions, leaving their evaluation to the distinguished panelists. And maybe I might be the luckiest speaker because I already have a question in the previous session, and maybe I would be able to answer to that point also in my speech. And as usual, I need to make it clear that today I will speak in my pure personal capacity, and what I speak is based only on my personal academic view. My speech does not represent the view of the chair of the Working Group on Jurisdiction or the view of the Japanese government. This is the table of contents. After the brief introduction of the jurisdiction project, I will explain the three main sets of rules in the draft provisions. That is, the rules for parallel proceedings, rules for related actions, and the rules for judicial communication and cooperation. Then, after discussing other issues to some extent, I will make my concluding remarks on the prospects of the project. So, let's move on to the substantive part of my speech. First, I will explain briefly the HCCH jurisdiction project, though it seems that you all would be familiar with it. Jurisdiction project is a legislative project of new international instrument dealing with matters relating to jurisdiction, including parallel proceedings and proceedings of related actions. It is a sister project of the HCCH Judgments Project, which Professor Zhang explained in the previous session. And the judgment projects produced two conventions: 2005 Choice of Court Convention and 2019 Judgments Convention. On those conventions, we have discussed in the previous session. However, the original objective of judgment project, as Professor Liu, who posed question on direct jurisdiction, correctly pointed out, the original objective is to work on two key aspects of private international law in cross-border litigation in civil and commercial matters, international jurisdiction of courts, and the recognition and enforcement of foreign judgments. The two conventions do not deal with matters relating to jurisdiction, except for the rules concerning exclusive choice of court agreement. So, the current jurisdiction project tries to add new pieces of rules by drafting a new convention on matters relating to jurisdiction, thereby seeking to establish a comprehensive system that was originally proposed. After the discussion in the experts group, CGAP 2021 established the working group and mandated to develop draft provisions on matters related to jurisdiction in civil or commercial matters, including rules for concurrent proceedings, that is, parallel proceedings and related actions, to further inform policy consideration and decision in relation to the scope and type of any new instrument. This was the mandate of the working group. And CGAP also mandated the working group to produce in an inclusive and holistic manner with an initial focus on the developing binding rules for concurrent proceedings. This is the initial mandate, or this is a mandate still we have, still CGAP has given to the working group. And 8 meetings have been held so far. And 8th meeting of the working group was held in February 2025, and the draft of the provisions on parallel proceedings and related actions for future discussion was adopted in the meeting. Yes. We can see the adopted provisions in preliminary document 2B of CGAP 2025, the title of which is Working Group on Jurisdiction Report of 2025. That document includes the draft text. The draft has 3 core sets of rules, as I explained at the beginning of my speech. Rules for parallel proceedings, rules for related actions, and the rules for flexible mechanism for communication and cooperation. But here, I need to answer to the Professor Ryu's question. I need to say that the working group will not develop provisions that directly regulate direct jurisdiction. As a preliminary document number 2A of December 2024, which was also submitted to the CGAP 2025. As the document shows, judging from the discussion in the working group, in particular, the divergence of views on jurisdiction rules, including the interpretation of the mandate itself, it seemed that it was no longer necessary or feasible to develop direct jurisdiction rules within the current remit of the project. I cannot foresee the future of the matters of direct jurisdiction rules, and any project in HCCH is always subject to the conclusion by CGAP. But direct jurisdiction rules might be further developed in a separate and subsequent project, as it has been suggested by some members of the working group. You will see the detail of the situation in the preliminary document number 2A of the CGAP 2025. This might be the answer to the question. Although the working group will not develop rules that directly regulate direct jurisdiction, it seems to me that the draft pursues the same objectives as the rules of direct jurisdiction for the enhancement of the basic principle, access to justice. The draft provides obligation of contracting state to suspend or dismiss the proceedings for the realization of the adjudication of the disputes in an appropriate forum, avoiding the possibility of the adjudication in an inappropriate forum. It would provide predictability and certainty for parties to the dispute concerning where to sue the defendant. The rules on parallel proceedings and related actions will reduce costs arising from the duplicated proceedings among courts of different states. Those rules would be helpful for avoiding the risk of irreconcilable judgments. Although draft only applies to the situations of parallel proceedings and related actions, it would also have precious values if the provisions are appropriately drafted on the matters covered by the current draft. That is the overview of the jurisdiction project. Let's move on to the next part. Here, I will explain the rules of parallel proceedings, which are included in Chapter 2 of the draft. Article 5 provides the basic rules or basic international obligations to deal with the parallel proceedings, that is suspension or dismissal of the proceedings of a court of a contracting state if there are other proceedings of a court of a another contracting state that have priority under the draft. There are four rules that determine the courts having priority to other courts. The first rule is on the proceedings on rights in rem movable property provided in Article 6. Courts of the contracting states in which immovable property is situated have priority over courts of other contracting states. The second is the priority rule on party autonomy. The courts of the contracting states designated under parties' choice of court agreement as having jurisdiction. Such courts have priority over other courts of other contracting states that are not designated under the parties' agreement. This rule does not apply to the exclusive choice of court agreement that will be dealt with under the 2005 Choice of Court Convention. Also, this rule does not apply when parties' agreement states that it does not deprive any other court or courts of jurisdiction. In other words, when purely prerogative nature is expressed in the parties' choice of court agreement. The third is the priority rule based on jurisdictional connection provided in Article 8, and the fourth is the rule for situations where two or more courts have jurisdictional connection provided in Article 9. I will explain those two rules using other slides. Let's imagine a hypothetical case. Company A is state K brought a machine. Company A in state K bought a machine from company B in state J. But because of the defects of the machine, which was handed over to company A at its factory in state K, company A could not use the machine as it planned, and therefore it could not hand over its products to another company and needed to pay the penalty of breach of the contract. Therefore, company A sued B for seeking compensation of damage based on the contract in a court of state K. And company B sued A for seeking the declaration of non-liability in a court of state J. This is just a hypothetical case, but there was a similar case in Japan. If one court of a contracting state, state K, has a ground of jurisdiction or connection, such a connection of price of performance, price of the delivery of the machine, and the other court of a contracting state, I mean state J, does not have a ground of jurisdictional connection under the instrument, then the new instrument justifies only the proceedings of state K, and it should be given priority. As a result, proceedings in state J shall be suspended or dismissed. The grounds of jurisdiction or connection provided in Article 8, Paragraph 2 seems to be in harmony with the grounds of indirect jurisdiction or indirect basis provided in 2019 Judgments Convention. Therefore, the new instrument would support the judgment, would support the 2019 Judgments Convention. However, Article 8, Paragraph 2 would be necessary to be discussed further, considering the difference of the matters of the draft from those of 2019 Judgments Convention. as it is pointed out in the paragraph 7 of the conclusions and recommendations of CGAP 2025. This paragraph will be discussed in the 9th working group meeting. Sorry. Yeah, next slide. As the draft uses jurisdictional connection to determine the court having priority, it would be necessary to consider the situation where 2 or more courts have jurisdictional connection. Which court should have the priority? On this issue, currently, Article 9 provides very complicated rules with many brackets, including interlinked brackets. It would mean that the members of the working group still have different basic views on this situation. It is not easy to simplify. It is not easy to simply explain the difference between the views described by the brackets. However, from my perspective, it might be the point of discussion whether the draft should regulate rigidly the situation, giving one court priority as far as possible. This is one position, and other position might be the draft should regulate the situation with some flexibility, allowing both proceedings to continue. In addition, this issue is interlinked with the jurisdictional connection provided in Article 8.2. More connection we add to Article 8.2, more cases will fall within the scope of the Article 9. Then probably certain rigid rule might be preferable. In this way, we might say that further consideration of this issue is necessary, analyzing holistically the relevant provisions. At least it can be said that fine-tuning or simplifying the Article 9 is necessary in the future discussion. Let's move on to the next. Rules for related actions. Yes. Chapter 3 of the draft, that is Article 11 to 14, provides rules on related actions. Those articles are provided ensuring flexibility and discretionary nature of the rule to consolidate the proceedings of related actions. Consolidation of the related actions will be realized under the instrument only when both courts of related actions have the same views on the questions, that is, A, whether a single court should adjudicate the entirety or any part of the related actions, and if so, B, which court is the better or more appropriate forum for resolution of the entirety or any part of the related actions. If both courts have the same views, then consolidation might be realized. In determining the better or more appropriate forum, the so-called better forum test is used, and the factors to be considered for the test and provided in Article 11, paragraph 2. What should be discussed in the future as for the rules on related action would be the definition of the related actions. Here on my slide, there is a typo. This is not the Article 4.1b, but Article 3.1b. I'm truly sorry for that. Please correct the information. Currently, definition of related actions is provided in Article 3.1b, but the provision has so many brackets which showed as the necessity of further consideration. In addition, distinction between parallel proceedings and related actions should also be discussed, as the rules for each matter are quite different. Therefore, what kind of concurrent proceedings will fall within the scope of the rules would be an important point of discussion for related actions. Let's move on to the next, the rules for judicial cooperation and communication. Chapter 4 of the draft provision, Chapter 4 of the draft provides rules for judicial cooperation and communication. It seems to me that judicial cooperation is appropriate, or I might say, necessary for the proper application of the convention. To apply the rules of parallel proceedings, it would be necessary to exchange information such as the point of time when a court is seized or the subject matter of the proceedings. For that purpose, judicial cooperation and communication might help the application of the convention. However, we need to carefully draft the rules of cooperation and communication mechanism, because what kind of cooperation and communication can be realized in a judicial system depends on foundations and basic principles of the judicial system that might differ from those of other jurisdictions' judicial systems. Therefore, flexible cooperation mechanism might be appropriate. Chapter 4 has 3 articles that provide directory cooperation and communication. Article 15 provides the general rules for cooperation and communication. Article 16 provides the rules for exchange of information, and Article 17 provides the joint hearings. As for the communication mechanism, that is, mechanism for the exchange of information, the draft prepares 3 methods of communication. First one is the direct court-to-court communication. If both contracting states to which the courts of the proceedings belongs, if both contracting states allow to use this method, the judges can directly communicate each other and exchange information. However, because of the rules of taking evidence, or because of the problems of the language used for the communication, it can be difficult or impossible for a contracting state to use this method. Therefore, this method can be used only between the contracting states that allow to use it. Next method is the communication through competent authority. It might solve some problems of direct court-to-court communication, for example, language problems. This method also can be used between contracting states that allow to use this method. In this sense, the draft leaves the use of this mechanism to the discretion of the contracting states. Third method is the communication through parties. The nature of this communication mechanism needs to be considered further. Some would consider that this mechanism functions as the usual process of parties hearing, in other words, usual taking evidence process through parties. But there might be some who think of this mechanism as a special communication method, using parties as intermediaries or messengers of the court-to-court communication. This issue of how the nature of the communication should be understood could be quite important because the contracting states need to allow to use this method. In other words, this method is the default method of communication, and other methods can only be used when both contracting states engaging in the communication allow to use them. In this way, draft provisions tries to establish flexible mechanisms for communication, preparing 3 methods, and contracting states can choose the methods. Although communication through parties is the default method, and all courts of contracting states must accept the method. let's move on to the next. But I don't have so much time, then I will skip this slide. But I just want to say, yes, there is a provision concerning joint hearings. And at the same time, if we provide joint hearings or other, in a sense, innovative way of judicial cooperation, maybe concerns may arise. Therefore, it be necessary to address concerns arising from the use of the communication and cooperation mechanism. For that purpose, to some extent, Article 18 provides rules. That is, any communication and any cooperation and communication shall respect each other's sovereignty, the procedural rights of the parties to the proceedings, and the confidentiality of information under the respective applicable national laws. And there, as I don't have much time, therefore I also need to skip this, but there are other issues, scope of application and general clauses. However, those issues are closely related to policy matters, maybe not in the working group, but in the further steps, if there is some. In those future steps or future stages, we will revisit those issues. Yes, this is my last slide. As my concluding remarks, I would like to talk a little bit about the future steps of the jurisdiction project. In 2025, the 9th meeting will be held for the discussion on Article 8.2 and for the review and fine-tune of the entire draft text. After the 9th meeting, not the working group, but the CGAP will determine the future process of the project. I personally look forward to the conclusion of the CGAP 2025-26 with optimism. To have a good conclusion, as an academic, I myself personally would like to consider further the development of the draft provisions, keeping in mind that the project discusses the convention used by future generations in the future global society. That's all my speech. Thank you very much for your attention.
Thank you very much, Kay, for having set the stage so nicely, explaining what the jurisdiction project is, and for having answered the question at the end of the previous session that the jurisdiction project is actually not about direct grants of jurisdiction, but more about coordinating jurisdiction in cases of parallel proceedings and related actions, subject to us finding a meaningful way to explaining the difference between parallel proceedings and related actions. I think that is still something that needs to be fine-tuned. Thank you very much. Without further ado, I pass the floor to Marcello Denardi as a first panelist. I will ask all panelists please to stay within the 10-minute time limit, if at all possible, so that we can keep the time as much as possible. But please, Marcello, you have the floor. And a round of applause for him.
Thank you again for giving me the floor, Mr. Moderator. Thank you very much. Madam Master of Ceremonies, sorry for my delay in reaching to the panel, but it was for a good reason. I was discussing academically my previous speech, so I believe it is sufficient reason to dedicate myself with enthusiastic at that moment, but sorry for the delay. My speech would address an attempt to answer a question proposed by Judge Min-Ho Do in the preparation of this, this panel. That question was established as a starting point of what we should present here. And I split the question in three, connected to the Brazilian tradition. This is my idea of answering then that provocative question. So the first part would be how the future convention might operate within the Brazilian legal system, my experience. But why this limitation to a specialized tradition, a national tradition? Because Brazil presents a situation in connection to the concurrent proceedings, related actions, parallel proceedings to come, some or more of these definitions, because there is an express statutory rule that forbids the Brazilian judge to consider the existence of a foreign dispute similar to what he has before him. So this is a particular situation making Brazil sterile, not affected by the foreign jurisdiction in this sense. So for us, it will be all new if you look only into this particular statute, but we have some exceptions that I would mention right about. The first thing that I would logically address is that we have a statutory rule that provides that treaty rules prevail over national statutory rules. So if we envisage a future jurisdiction convention, whatever the name of it, a future convention dealing with this stuff we are trying to address here, in Brazilian law, we could include a microsystem of that particular treaty law to deal with these new cases. But when I say about a microsystem, someone would think about a very narrow number of cases, which we expect not to be in this future convention. So from a Brazilian point of view, a lot of disputes that we already have in Brazil might be affected of the need for judges to understand what happens in the other jurisdiction and try to adjust to that situation. So this would be new. The legal technology would not be properly new for a Brazilian judge because we have this problem internally, but of course would be new in the sense of the transnational or international litigation. So this is the situation that we have. But we are not absolutely unaware of the foreign disputes. We have two treaty law. I would name three, but we have two treaties that corresponds to the scope, envisage scope of the future convention, that are the Mercosul Protocol de Buenos Aires, the Buenos Aires Protocol that deals with contract, and within that environment of contracts, it states that a direct rule for jurisdiction, that is the court chosen. So this is a choice of court is the rule for direct jurisdiction, and also an indirect rule for jurisdiction, that is, if it is rendered by the chosen court, then it shall be recognized and enforced. So we have some experience. Case law is very little, but we have, from a logical point of view, an exception to the general rule of prohibition for judges to acknowledge the existence of foreign proceedings. The other is an older treaty, it's the Bustamante Code. It's a code, it's a body of law that is a traditional one. It was constituted by a convention in 1924, if I'm not wrong, and entered into force only for 9 countries in the Americas. It is a treaty now under the Organization for American States, and Brazil is the largest country in economic terms that is part of this code, and the other countries are countries, very small countries that Brazil doesn't have that much of a relationship. So there is very little case law connected to Bustamante Code, and the rules are outdated for now, so more than 100 years, although it is a very interesting body of law to be studied. But Bustamante Code holds also the rule for contractual relationships connected to the chosen court, and both a direct and indirect jurisdiction basis on that situation. So I would cite also the 1980 Child Abduction Convention of HCCH, although it doesn't correspond to the scope of a future, the envisaged scope of the future convention, but it is, in my reading, one convention that deals with jurisdiction in the sense that it removes jurisdiction from the place where the child is to defer that to the habitual residence, as it was mentioned yesterday a number of times. So this is in force in Brazil, and we have practical cases in that situation. In case law, we have recent interaction with the estoppel common law cases, the orders to stay proceedings in other jurisdictions. We are trying to adjust to learn how those would work within our jurisdiction. So we have this. And the thing is that those kinds of orders in foreign jurisdiction come into Brazil by means of the parties. So the parties tend to abide or ask the Brazilian court to stay proceedings at least just to abide to the foreign ruling on this kind of decision. So we don't have that much case law, but it's a new coming thing that states the interaction of Brazil, the progressive interaction of Brazil with the foreign proceedings. We have some cases connected to arbitration, so stay arbitration in Brazil, stay the judicial proceedings in Brazil when we have arbitration abroad. So this is a clear solution, and this can be extracted directly from the statute. Benefits that the jurisdiction convention may bring in Brazil, in the Brazilian context, particularly due to the having of a rule forbidding Brazilian judges to acknowledge foreign litigation between the same parties, to learn. That is what we have, a different opening to the existence of a foreign jurisdiction that would be maybe proper, maybe more advanced in the sense that the proceedings are more advanced in time, the evidence collection and stuff like that, or more near to the evidence to be much easier to collect. And this stuff is not dealt with by Brazilian judges in the international. So, on the other hand, the persistence of this rule in our statutory law may prevent politically the accession from Brazil into a new convention. So this key element might be a difficulty that would need to be tackled in the future convention if we wanted to be enabled in Brazil. So reaching my time, I would like to say that if we have the third part of the question will be what are the aspects that could be further improved in the project. From Brazilian point of view, the difference of rules between parallel proceedings and related actions that Kai has presented already doesn't make that much sense for us. We understand that there is a need in the current status of the discussion and negotiations. We need that differences and the different rules, but for us it would be much better if there will be similar rules for the two situations. And finally, if the convention comes to light and Brazil enables it in its internal law, then Brazilian judges might have a new field, and Brazil would have a new opportunity to join a community of judicial activity more clearly and with more understanding of this world jurisdiction idea that we are debating. Thank you. And if you allow me a few seconds, I just would like to debate an assumption of the question that came at the end of the previous session. That is, we don't have the direct jurisdiction rule in those conventions. We do have. Choice of court has a direct jurisdiction rule, and that is a double convention, as mentioned before. Thank you very much.
Thank you very much, Marcelo, and in particular also for having digged further into this question of the interaction that exists between the negotiation of a new instrument and the framework provided by your internal legislation, and how flexible a state can be or should be in those negotiations with a view to achieving a meaningful international result. And then in comes also the political constraints that you are subject to, and it then comes to a possible ratification of a treaty that changes the domestic law. Thank you very much for that. Without further ado, again, would like to give the floor then to Kyung-Min Yo, who has been introduced already from Singapore and who will provide us with a perspective from Singapore, maybe. You have the floor. Thank you.
Right. Thank you very much, Christophe. Right. I'm very sorry to impose on all of you again. I've been tasked to address the question of what benefits the new instrument would bring to Singapore. So this is how I propose to address the question. I need to first set out what is the current position in Singapore, how this new instrument in its working draft form today changes the position, and then what benefits or problems that could bring. And I will use an example of a real case that we had in Singapore to illustrate the difference. Right. Okay, so the underlying basic philosophy of jurisdiction in Singapore is that a trial should be heard in the natural forum for that trial, right? So basically, a forum which is natural forum is the forum which is best placed to dispose of the case from the perspective of the parties and in the interest of justice. Now, jurisdiction rules in Singapore formed by two subparts. No jurisdiction, the court will not hear a case unless these two parts are answered in the positive. First, there must be the existence of a nexus for taking jurisdiction. This is a hard rule. You either have it or you don't have it, right? And over the years, they've grown quite broad, right? So basically, today we are talking about presence, submission to the jurisdiction, and a wide range of statutory grounds for service out of jurisdiction in cases where the defendant is outside jurisdiction. But that only establishes the nexus, right? Jurisdiction is not complete until the court is satisfied that it should exercise that jurisdiction. And this second bit is discretionary, and it's a very sophisticated set of rules that developed on how to determine which is the natural forum to hear the case. And this is sometimes used in the Latin forum conveniens. And within this framework, concurrent proceedings, parallel proceedings, and related proceedings are factors to be considered. Sometimes they're more important, sometimes they're less important, especially if the factors were manufactured by the parties, then they'll be regarded as less significant. If there are genuine proceedings going on, then there'll be a much more weighty factors to be considered, right? So this is the current basis for taking jurisdiction, and this is the way that we proceed to deal with related and parallel proceedings today. Okay, so what difference, what changes would the new instrument make to the current position? Well, the current position, as I've said, is based on forum convenience, and there's also a very important aspect of the procedure, case management tools, where the courts can sometimes stay different parts of the proceedings for foreign courts to hear different bits of the case. And between forum convenience and case management, the Singapore courts have tremendous flexibility in how they manage cross-border cases. Now, what changes? The delta reflects the change made by the instrument, right? What changes would this new instrument bring to Singapore? First, I think there is the potential gain in terms of better informed and more efficient decision-making processes from the communications protocol, because when the courts are better informed about what's happening in the other jurisdiction, they can make better and more efficient decisions. Right. Potential gains in terms of future development of innovative dispute resolution methods, including improved methods of consolidation, coordinated split trials, and possibly joint trials where appropriate. And this, I think, will take time to develop, but this instrument opens up the possibility of this sort of development. Right? The potential downside could be the complexity of the mechanism, and which could possibly, in some cases, increase the costs of jurisdictional litigation. Okay. Now, what I've just set out is particularly significant for related proceedings, because the related proceedings under the instrument sets out a rather open-textured approach towards how to deal with related proceedings. Okay. Now, the parallel proceedings are a little bit more complicated because at present we don't have any specific rules to deal with parallel proceedings. Under the current law in Singapore, there is no legal doctrine of lis alibi pendens, right? And which court is first seized is only one factor in the forum convenience analysis. And under the current approach, this is how we deal with parallel proceedings. Some parallel proceedings have a common plaintiff, others do not. Sometimes A is suing B in two jurisdictions, sometimes A sues B in one jurisdiction, B sues A in the other jurisdiction. Where the situation does not involve a common plaintiff, then forum convenience simply applies. The court simply decides, are we the most appropriate court to hear the case in the circumstances, given that there is this other jurisdiction, which is where proceedings are also going on. The common plaintiff situation is slightly more complicated because that can invoke two separate doctrines. One is the forum convenience doctrine, as discussed, and the other is the forum election doctrine. What is the forum election doctrine? Basically, we say that if the plaintiff is suing on substantially the same claim for substantially the same remedy in more than one jurisdiction, this is prima facie an abuse of process. And this cannot be allowed. The plaintiff must elect one proceeding and stop the other proceeding unless exceptional circumstances can be shown to justify multiple proceedings. Okay? And the practical approach in this type of situation, where the defendant raises both forum convenience and forum election arguments, is this. The Singapore court will first determine whether Singapore is forum convenience. If it is not the forum convenience, then the proceedings are stayed, and that's the end of the matter. No question of forum election will arise. If the Singapore court determines that it is the natural forum in the circumstances, then the plaintiff will be required to make the election. You either carry on in Singapore as the natural forum, or you stop the proceedings, and, well, you do whatever you like in any other jurisdiction. Now, the parallel proceedings rules in the instrument are hard or harder rules, right? We don't have the open-textured approach in related proceedings anymore. And so this will be the biggest change for Singapore, for parallel proceedings, where the open-textured discretionary approach will be replaced by a hard rule approach. And a second change would be actually in the philosophical objective. The philosophical objective, as I said, in the common law position is to get the case to the natural forum somehow. Right? Of course, that means if we are the natural forum, we hear the case. If we are not, we don't hear the case, but we try to massage the parties to go to the natural forum. Okay? But that is not the same philosophy as in the instrument. The instrument's philosophy is really decide between two concurrent proceedings which one should hear the case. The difference is that from the common law approach, sometimes neither are the natural forum. You should go to a third forum. And the instrument does not deal with that situation because that is simply not the philosophy of the instrument. So there's a philosophical change that we will have to deal with if we adopt the instrument. And let me give you an actual example of a case. Right? Here we have the plaintiff is a BVI company controlled by a Russian oligarch. This company bought many artworks through an intermediary, B. B was introduced to the oligarch by R, another party, okay? Now, 4 of the contracts between A and B contain choice of Swiss law and exclusive choice of Swiss court clauses. And the rest of the transactions were by invoice only, right? But neither party actually raised the choice of court agreement issue in the litigation in Singapore. Now, most of the connections in this case were to Switzerland, some to Singapore. B, the main defendant, was a Swiss national resident in Singapore. R, the second defendant, was a Swiss a Swiss national resident in Monaco. Okay, the oligarch himself, which was the brains behind A, right, was resident in Monaco, previously in Switzerland. So very, very international case, right? So A, of course, be prodded by the oligarch, made a police report in Monaco alleging that B and R, the 2 defendants, had conspired to inflate the purchase prices of the various artworks, thereby causing loss to A. And part of the allegation was that R had received secret commissions from each of the sale, with the result that B and R were arrested in Monaco and charged with fraud in Monaco. Now, A then joined the criminal proceedings in Monaco as civil party claiming compensation. Okay, A subsequently sued the defendants in Singapore for breach of equitable duties, being breach of fiduciary duties, dishonest assistance, knowing receipt, and the tort of conspiracy. No claims were being brought against B for breach of contract, I think for strategic reasons, because A didn't want to bring up the Swiss connection. What was the reason for coming to Singapore? In part, to seek equitable proprietary remedies, injunctions, and so on, and interim worldwide asset freezing orders, which you can't get from most civil law countries and some common law countries, right? But these are remedies that were available from many common law countries, including the Singapore courts. Now, B and R then applied to stay Singapore proceedings on the basis that Switzerland or Monaco were more appropriate, and alternatively that A should have to elect between Monaco and Singapore, because here we have parallel proceedings with a common plaintiff. Okay, the High Court had allowed the claims to proceed in Singapore, but the Court of Appeal overturned it, and the Court of Appeal decision is, of course, a critical one. All the Singapore proceedings were stayed on the basis that Switzerland was clearly the more appropriate forum. So the case was basically dismissed from Singapore, and the forum election did not arise as an issue. And the practical result of this decision, on the actual result, is that all the civil claims were heard in Switzerland. Right. The stay in Singapore was granted on the basis of certain undertakings by B&R to submit to the jurisdiction of the Swiss court, because this issue had arisen in the Singapore jurisdictional battle. There was a question mark whether the Swiss courts had jurisdiction over B&R, and that was resolved by the Singapore courts by getting the parties to undertake to submit to the jurisdiction of the Swiss court. Okay, so this was the actual result, in this case under Singapore law, and the result was consistent with the policy of the common law that the case should be heard in the natural forum. What would happen if we apply the draft instrument as it stands today? Well, the first question would be whether the instrument would apply at all, because the civil claims in Monaco were not strictly civil claims, it was civil proceedings within criminal proceedings, right? And I think one question would be whether this sort of claims would fall within the new instrument. We have not addressed that question explicitly. The answer is probably yes, because of the alignment with the 2019 Judgments Convention, because judgments arising from this sort of civil proceedings do fall within the 2019 Convention. So without committing the working group to any view, it's likely that this will be caught. Right. Then assuming this will be caught, this is actually an Article 8 situation. Why? Because A's claim against R in Monaco, for A's claim against R in Monaco and Singapore, Singapore did not assume any Article 8.2 jurisdiction, but Monaco did. Why? Because B was resident in Monaco, B was not resident in, R. We're talking about R. A against R. Singapore did not assume Article 8.2 jurisdiction, but Monaco did because R was resident in Monaco. R was not resident in Singapore. As a result of which, Singapore should dismiss the proceedings and the trial would be heard in Monaco. Okay? For A against B, some of the claims will be caught under the exclusive choice of Swiss court agreements and therefore under the 2005 convention, right? And they'll be out of scope of this instrument, right? But for the remaining claims, Singapore had assumed Article 8.2 jurisdiction because B was resident in Singapore, but not resident in Monaco, no other connections in Monaco. And so what happened as a result would be the Monaco court should dismiss or at least suspend the proceedings and the trial should take place in Singapore. So the immediate effect of Article 8 is to split the proceedings between Monaco and Singapore. Okay? Now, query in this case is whether the defendants can apply to the Singapore court to compel A to make an election under Singapore rules of forum election, right? And again, there's a question mark there. There's a new article in the instrument, Article 20, that might address this question, but I think there are question marks whether it will stay there or not, and if it stays there, whether the language is broad enough to capture this situation. Right. But having the proceedings split is not the end of the matter, right? Because having split the proceedings, they are still related proceedings. So Article 11 on related proceedings would be triggered, and what will happen is that, well, the Monaco court will apply Article 11 to see whether the claims in Monaco should go to Singapore, right? And the Singapore court will apply Article 11 to decide, well, what it should be doing, right? And this is where I think the provisions, the open textures provision of Article 11 would make a would be extremely helpful, and with the communications protocol between the two countries, if they are willing and able to speak, would actually allow for a very efficient resolution of the related proceedings conflict in this case, which would actually be an improvement over the current situation in Singapore if the communications protocol can be used. So the possible outcomes under Article 11 is maybe all heard in Monaco, maybe all heard in Singapore, or heard partly in Monaco, heard partly in Singapore, maybe heard jointly. But one big difference is that there's nothing in here to massage the case to Switzerland. Right? And so this is, I think, the philosophical difference between the instrument and the common law, right? So that's the philosophical aspect. The practical aspect is, I think, going to be this. The rules for parallel proceedings are very complex, right? And so the question that the Singapore authorities will need to think about really hard is it worth signing on to this complex instrument? Does the common law give a more efficient, faster, quicker, one-step solution rather than the multiple-step solution that the instrument provides? And that's what I think will require very hard thinking. So in conclusion, I think the provisions on related proceedings will be a very easy sell to the Singapore authorities. The provisions on parallel proceedings will be a hard sell. That is my own personal opinion. Thank you very much.
Thank you very much, Yoming. Fascinating. And at the risk of, and I apologize in advance, at the risk of completely losing control of the time management, I have a question, a follow-up question. Because you refer to the authorities of Singapore when they will have to decide whether or not to join such a convention, in particular in terms of the complexity of the rules on parallel proceedings. But is there not another risk that the litigators in Singapore, Singapore being a dispute resolution hub, that the litigators will tell the government, we actually like the current situation and we like to plead these cases on the basis of forum convenience or forum non-convenience. We don't want a strict regime. We like the current situation because it suits us, it suits our profession. Is that a risk in your view, or
well, that was one of the considerations when I said that the authorities, it will be a hard sell to the authorities, because the authorities will, of course, consult the practitioners, right? And this is a view that the practitioners will convey to the authorities. But I think the approach of the authorities will, of course, be a view that will not be dictated by what the lawyers say. I mean, what the lawyers say will be important, but it's only one aspect of what the country is trying to achieve, right? And the question is, at the end of the day, will Singapore be improving its position from what it is? And if the lawyers don't like it because it's too complex and complexity increase costs for litigation, then the authorities are likely to say, well, practitioners, you have a point.
Thank you very much again. Some work to be done to simplify the rules on parallel proceedings. Without further ado, I give the floor to Professor Inoue for a Japanese perspective, I presume. Thank you very much.
안녕하세요. Good afternoon. I'm Professor Inoue from Japan, and as you noticed, my family name includes 4 in 5 vowels in alphabets. Then this family name causes always the pronunciation problem all over the world. Only A is lacking. That is reserved for our distinguished colleague, Professor Hayakawa. So just call me Professor Inoue, just read it like Italian. By the way, today I'm going to give you a short speech on the Japanese perspective on the jurisdiction project and possible impact on the Japanese law in the future. How? Oh, thank you. Okay, then I'll first give you a case study, and then after that, I'll explain about the current Japanese law, and finally, I'll give you some thoughts on the possible changes or impacts on the Japanese law given by the draft convention or the future convention of our jurisdiction project. Now, let's first about the case. This is, of course, a fiction. Here, a Japanese company located in Tokyo sold machines to the Tokyo branch of a Korean company, but one of the machines got broken afterwards. The accident caused huge damage in a Korean factory of the Korean company. Then they decided to file a lawsuit in Seoul, seeking for damages from the Japanese company for their product liability on the machine. We call this first proceeding as Claim A. However, Japanese companies thought they were not guilty, and for some reasons, they did not want to respond to the Claim A in Korea. Highly probably, they got terrified with the white liquor, strong white liquor in Korea, and their terrible drinking culture. Then they avoided the claim, responding the Claim A, and they chose to file another lawsuit in Tokyo and asked the Japanese judges a negative declaratory judgment so as to cancel their product liability under allegation. We call this second proceeding as Claim B, and you can see that the Claim A and B consist of mirror images over the liability of the Japanese company. Claim A seeks for remedy, whereas claim B seeks for immunity. In addition to that, the Japanese company raised another litigation in Tokyo, which we hereafter call Claim C. That is to revoke the whole transaction between the Japanese company and the Korean company, asserting that the Tokyo branch of the Korean company committed fraud on the requirements and standards of the machines, and that which gave the requirements on the standards of machine, and which had something to do with the accident in Korea. And the Japanese company asked the restitution in Tokyo. This is Claim C. Then here is a question. What should the Japanese judges do for Claim B and C before them? Claim B is the parallel proceeding with Claim A in Korea, which was raised earlier than Claim B. On the other hand, Claim C has only scant connection to Claim A. And Claim B and C both enjoy the direct jurisdiction in the Japanese court because Claim B is about the product liability, and it's the allegation that the Japanese company committed negligence in Japan. That's the connection. And Claim C is about the transaction conducted by the Korean company, but by the Tokyo branch. And the whole transaction were made in Tokyo. Then this is the connection. Therefore, under Article 3.3 of the Code of the Civil Procedure in Japan, the Claim B and C both enjoy the direct jurisdiction in Japan. Okay, and now let me introduce the current Japanese law. Please look at text. I say it hesitantly because this is a full line of words, a full of words. I'm sorry for that, but this is Article 3.9 of the Japanese Code of Civil Procedure. In short, this article gives Japanese courts discretion whether to give a judgment on the merit of a case before them or not. Even they can find causes of international jurisdiction of Japan. In case judges find that the case has special circumstances, showing it should be tried not in Japan, but by a proper court outside Japan, they can simply dismiss the case under Article 3.9. As a result, the parties to the case are made to file the lawsuit in the proper court to obtain proper remedy outside Japan. Clearly, this article is enacted under the influence of so-called forum non-convenience theory in Anglo-American jurisdictions derived from Scotland. The article exemplifies factors to be considered when judges making their decisions, which count such as equity of parties and a fair and speedy trial, and so on. However, these factors shown in the article are still vague and abstract. Then the next question is the real operation of Article 3.9. How should Japanese judges exercise their discretion in practice? Our question includes whether Article 3.9 be applied to lis alibi pendens cases or not, because it does not directly refer to parallel proceedings and related actions provided in our draft convention. And here is a case law on the article given by the Supreme Court of Japan on the 10th of March 2016. In this case, the plaintiff was a Japanese manager. He was working in an American company as a manager, but he was fired for the allegation of his misconduct, namely a bribery to foreign government officials. Then he and the company got involved in a series of litigations in America over his status and damages and so on. On the course of the dispute, the company announced through the internet his allegation of his misconduct into public. Then the Japanese manager or a former manager thought the announcement as defamation to him and raised another action for damages not in the United States but in Japan, where he thought his fame was severely damaged. As you noticed, although this Japanese case is originally derived from the dispute in America, it is not parallel to litigations pending before American courts. We see no lis pendens as subject matters are very much different to each other. The Supreme Court decided that the Japanese proceeding be dismissed under Article 3.9 of the Code of Civil Procedure and made it clear that Japanese judges were allowed to take ongoing foreign proceedings into consideration when they exercise their discretion whether to dismiss the case before them or not. As is mentioned, this case was not the parallel proceedings to American litigations, and then we can reasonably assume that the Supreme Court would be happy to apply Article 3.9 and dismiss the case when it came to the parallel proceedings. And if we apply this case law to that scenario between the Japanese company and the Korean company, we can suppose that Claim B, the counterpart of Claim A in Korea, will be dismissed highly probably. On the other hand, we cannot predict with certainty and precision whether Claim C, the related action, be dismissed or not. We must wait and see what judgment will be made until the last moment. So far was the explanation of the current Japanese law. At the moment, this current Japanese law is treated without serious problems. Not everybody would be happy, but the majority seem to be happy with this current Japanese law. One is a very abstract statute. The second is another vague case law. Why they are happy? One reason may be that the Japanese judges are generally very much trusted by the parties. By the way, I used to be a Japanese judge. I worked as a judge for 20 years, okay? And just trust me. But from the foreign perspective, statutes are very vague and case law is also very abstract. Then the majority of foreign people would not have the certainty and predictability about the Japanese international jurisdiction. That is understandable. Then, what would take place under the new convention? What kind of impact we would expect when we ratified the convention? Of course, our presumption is that both Japan and Korea are contracting states to the convention. Now let's start from the treatment of Claim B. We find that both Claim A and B are within the scope of the convention through the application of Article 2, as well as parallel proceedings under Article 3, Section 1, Subsection A, because they share the same parties on the same subject matter. Next, we find claim A satisfies Article 8, Section 2, subsection D and G, whereas claim B also meets the requirement of subsection C and G of the same section. So, claim A and B are connected under the convention. Therefore, we step forward, applying Article 9, the core article of the convention. This article is to provide priority for the first court seized, that is the Korean court in charge of claim A in our scenario. Then, Japanese court would be obliged to suspend the proceeding on claim B. That is the outcome of the application of the convention. Then, under our convention, Japanese judges would be deprived of their discretion whether to dismiss claim B given by Article 3.9 of the Code of Civil Procedure. This change would give the parties and the potential users of Japanese courts clearer predictability on the proceedings of the cases, along with certain flexibility on the treatment of the cases, as they would not simply be dismissed, but be kept suspended in the courts. They can be resumed in the in the future under certain conditions provided by the convention. Next, let's think about the application of our convention to claim C, the fraud case. Here, we confirm that claim C is within the scope of the convention by Article 2 and that under Article 3, Section 1, subsection B, claim A and B can be related actions where the parties are the same facts arising from the same transaction and one or more common questions of law or facts may create a risk of inconsistent judgments. Therefore, we go to the procedure set out in Article 11 and 12, where the Japanese and the Korean courts determine the proper forum between them. During their determination, the judges of two contracting states can make full use of the communication mechanism provided in Article 16. The mechanism would give them better knowledge on the related actions each other, which enhance the quality of decisions. If it works successfully, then the parties will enjoy the opportunity of having judgments by the better court. However, I personally feel that we need to pay relevant attention to a language problem. For instance, Anglo-American judges have very few troubles to communicate directly as they share the same language and the same legal culture. But the Japanese language is spoken only in Japan, and average Japanese judges have little command on foreign languages, including English. Just trust me, I used to be a Japanese judge. Then, in order to make the communication mechanism work well, we have to be sensitive to the reality of language skills of people concerned. And thank you very much for your attention, and I do express my sincere gratitude to you all, as well as the expectation for our future convention. 감사합니다. Thank you very much.
Thank you very much, Professor Inoue, for the Japanese perspective, again showing also that I think we have some more work to do on the convention text to integrate it more effectively into existing systems so that it brings an added value. But no time for further follow-up questions or comments. Without further ado, I would like to give the floor to Ms. Lee for the Korean perspective, I guess. Thank you.
Thank you, Dr. Bernasconi, for giving me the floor. Good afternoon, distinguished guests and colleagues. My name is Haemin Lee, and I currently serve as a research judge at the Supreme Court of Korea. I personally had the honor of participating in the experts group for this project under the chairmanship of Professor Takeshita. And later, during my secondment, I had the chance to support this project group as a member of the Permanent Bureau under the guidance of Dr. Bernasconi. And therefore, it is a particular privilege for me to be speaking here today in this group. And good news for everyone, I'm the last panel today, and I'll try to make it very concise. As previously mentioned, the jurisdiction project seeks to establish uniform rules for international jurisdiction and parallel proceedings. While significant progress has been made through 8 sessions of the working group, several complex issues still remain unresolved. One of the central challenges lies in reconciling 2 fundamentally different doctrines, namely the first-in-time rule and the better forum approach, which reflect the diverging views of civil law and common law traditions. Against this background, in July 2022, Korea undertook a major legislative reform of its Act on Private International Law, introducing a hybrid model to address the issues of parallel proceedings and forum nonconvenience. Article 11 of the Act on International Parallel Proceedings primarily follows the first-in-time rule. It permits a Korean court to stay proceedings if a case concerning the same matter is already pending before a foreign court and the resulting judgment is expected to be recognized in Korea. However, this is subject to 2 exceptions. First is when the Korean court has exclusive jurisdiction under an international jurisdiction agreement. And second is when it is manifestly more appropriate for the Korean court to adjudicate the matter than the foreign court. As you may have noticed, Article 11 proactively reflects some of the ongoing discussions in the jurisdiction project and its emphasis on the priority of the first-in-time rule. However, a key difference lies in the fact that Korea's provision adopts a discretionary approach by prescribing that Korean courts may stay the proceedings, whereas the HCCH drafts adopt a mandatory suspension mechanism in similar situations. If I may go a little deeper in the underlying definitions, the draft's definition of parallel proceedings refers to proceedings in different contracting states between the same parties and involving the same subject matter. However, the meaning of these core elements still remain bracketed in the draft text. Traditionally, under Korean law, which is based on civil law tradition, duplicative litigation is prohibited, and it is determined according to the subject matter of the claims. Whether this traditional civil law-based standard could still be applied in cross-border parallel proceedings regulation is subject to further exploration. Another key feature of Korea's revised act is that, for the first time in Korean legal history, Article 12 introduces a rule close to the doctrine of forum nonconvenience. It allows a Korean court, even if first seized, to decline jurisdiction where the proceeding would be inappropriate, and a foreign court is clearly more appropriate for resolving the dispute. Although there is no specific statutory provision addressing related actions, Article 12 may also be applied in such cases. While the HCCH draft also adopts a similar approach, it does so in mandatory terms by using the wording shall decline, whereas Korean law retains judicial discretion by using the words may decline. However, unlike the draft, Korea's statute does not enumerate specific factors for assessing the better forum, leaving room for Korean courts to develop further jurisprudence. One major exception is the element of the likelihood of recognition and enforcement of a foreign judgment, which has already been reflected in the Article 11 of the Act. Another major issue to be noted is the critical role of the party autonomy. Similar to the draft, Korea's new act respects exclusive jurisdiction agreements, excluding relevant provisions where such agreements exist between the parties. The draft also emphasizes cooperation between courts by introducing mechanisms for communication and coordination. And this is a meaningful development. However, it requires careful consideration, especially in light of concerns over procedural fairness, confidentiality, and judicial sovereignty. Korea also has relevant experience, particularly in cross-border insolvency proceedings, including the use of the JIN guidelines, which enabled effective judicial cooperation. And these practices reflect the feasibility of court-to-court communication and may serve as precedents for broader implementation of the HCCH framework. In conclusion, the HCCH jurisdiction project is a crucial effort to create an international framework, resolving the issues related to international jurisdiction, including the issues of parallel proceedings and related actions. This project also highlights a significant step toward a gradual unification and coordination of domestic laws. In this regard, I believe that Korea's reform represents a meaningful legislative initiative to harmonize conflicting principles, and I hope that Korea's ongoing experiences will continue to contribute to the success of this project. Thank you very much for your kind attention, and I hope you have the chance to enjoy Summer Nights of Korea. Thank you.
Thank you very much, Judge Lee, for this Korean perspective, and a particular thank you also for being so concise in your remarks and yet very informative. I really appreciate it. I think we don't have time for anything else, but a big thank you to all our panelists and the speaker for your learned and very informative presentations. Please join me in giving them a big round of applause.
Thank you very much. I appreciate all participants of this session 7 for actively sharing their insights and opinions. We are now coming to the end of today's conference. Through in-depth discussions led by legal experts, I believe we may have made meaningful progress in identifying a desirable path forward for international judicial cooperations in service and taking of evidence, as well as for jurisdiction and recognition and enforcement of foreign judgments. It was my great honor and pleasure to be the MC of today's conference. On behalf of the organizers, I'd like to extend my sincere gratitude to moderators, speakers, and panelists for their valuable contributions based on their expertise. And I appreciate to all participants who have attended this conference both online and offline. Let us give a big round of applause to all participants. This concludes day 2 of HCCH Asia Pacific Week Seoul 2025. We wish you a restful evening and looking forward to welcoming you again tomorrow. Thank you.